petition by 24 method. I have filed for IF for bail method. And another one is 564 by 21. And say IF for bail.
The lawsuit formation. Criminal appeal lawsuits have been placed to us admit and called for the LCR directed the IF for bail to be listed after the receipt of LCR.
Notice list item number 1.
Petitioner is going to retire on July 2025. Challenge the order of promotion. Even though there is notification that if a person is retired within stipulated time, then the petitioner should be get appointment on his post. That is the promotion.
Item number 1. Taken up 1 week after, Mr. Simanta Das is out of station to attend some medical emergency.
Who is?
Mr. Simanta Das. He has gone out of station to attend some medical emergency.
Just a minute. The Roth Office placed that order that 22/1/2025. The matter is taken up through hybrid mode arrangement. The writ petition has been filed by the petitioner Damodar Pradhani inter alia challenging the order dated 27/9/2024 passed by the learned special judge special court Bhubaneswar in TR number 15 of 35 of 2015 in rejecting the petition under section 239 CRPC filed with the petitioner for discharge and fixing the case to 22/10/2024 for consideration of charge. Mr. Ajipatlan, counsel for the petitioner submits neither on the date fixed, that is 22/10/2024, nor thereafter charge has been framed. However, the case is posted today for framing of the charge as per his instruction. He submits there are two connected writ petitions which are sub judice before this court, that is WPC number 23609 of 2024, filed by the present petitioner, which has been filed for passing the order of taking cognizance, and another WPC number 13653 of 2022, which has been filed by the co-accused. Sandhya Pradhani, Mr. Rath, further submitted that the other co-accused, Somvejit Pradhani, has not filed any application in this court challenging the proceeding or any other order passed by the learned special judge special court Bhubaneswar in TR number so and so of 2015. He has produced the order dated 21/2/2023, passed in WPC number 13653 of 2022, from which it appears that in IA number 724 of 2022, this court, while fixing the date of hearing of said writ petition to 21/3/2023, observed that the framing of charge in the proceeding in TR number 1535 of 2015 shall wait till then. However, it appears that though the said writ petition was listed before this court on some days thereafter, but after 11/9/2023, the interim order which was passed on 21/2/2023 has not been extended. However, learned counsel further submits that though no specific order has been passed extending the interim order, but there is no order for vacating the interim order. Since the petitioner has challenged the rejection order passed by the learned trial court in a petition which was filed under section 239 CRPC for discharge, Mr. Rath shall satisfy this court on the next date as to why he has not filed a revision petition challenging the impugned order, as in view of the ratio laid down by the Honorable Supreme Court in the case of VC Shukla versus State through CBI reported in AI 1980 Supreme Court 962, the said impugned order is not an interlocutory order. If any application for adjournment is filed today before the learned trial court, appropriate order shall be passed by the learned trial court, put up this matter on 28th January 2025, along with WPC number 23609 of 2024 and WPC number 13653 of 2022. What happened on 22/1/2025 in the trial? My lords, that date he has given another date. He has fixed it on 3rd. That is my instruction. I will produce the copy on the next date. The framing of charge Your Lordship, I have come ready with satisfactory expert. It requires a bit more of paperwork, but number of decisions have come up during this stage. So far as interlocutory order, it's a final order, revision, vis-a-vis the Special Courts Act, which your Lordship will examine under the PC Act, the provisions, under the Letter Act, which has come of the Orissa Special Act, which the President has given assent to. The provisions were laid down before the President. That assent has been given to. So, under such circumstances, when the presidential assent has been given to under Article 254(2), the consistency of the provision and repugnancy has to be examined, which has already a judgment has been laid down by Justice Mishra and Deepak Mishra and my Lord Justice Dave. That judgment under the Special Court Act, various provisions have been discussed with regard to these provisions. So, with the
That
Presidential
there
Act,
the validity was challenged. And
the
they
validity of
upheld
the
the
Special Courts Act was
Here on a
challenged.
simple point,
Yes,
your petition under section 239 CRPC
yes, yes,
has been rejected
Yes.
for discharge.
yes. There are three petitions here. So, now the point
No,
here,
once you see, once this stage has gone, this petition is meaningless totally. This filing for quashing of cognizance. Because
no,
now,
that
now
that
it is at
case,
the
that
stage
case,
of-
I have filed the entire details. It is for quashing the proceeding. I am insisting on that petition for quashing the proceeding so far as section 109 is concerned under the IPC, wherein specifically sanction was not taken under section 197. Then to get over the Corruption Act, with certain decisions,
we
there
are,
was
we are first taking of the first matter.
no, your lordship says that all the three matters will be connected. The other matter has been fixed to February. Those last two matters, connected matters.
First, you have to satisfy that why against the 239 CRPC rejection order, you have not filed a revision petition, why you have filed the that is
Yes.
the first thing
Yes,
you are
yes. First, for that, my special contention first before your lordship would be kindly produce the order sheet of which has been passed in initially in WPC number 13653 of 2022. That is the case of Sandhyarani Pradhani. No, sorry, 23609 of 13653 of 2022. They filed it again. Now, first of all, when we came up before your lordship, I had filed a criminal CLMC, which your lordship was hearing also at single. Time to time, your lordship had heard that matter. But suddenly, when the bench was composition was the roster was changed, the matter was also heard by Justice Mahapatra. But in between, the Vigilance Council raised an objection that this is a matter which has come up under the special statute. That was also against the discharge petition and to quash the proceeding.
no discharge petition. What is the question of discharge at that stage?
My lord?
You have come up in that case challenging the cognizance order.
No.
Discharge
My lord,
came-
cognizance was incidental,
Yeah.
and but the main thrust of my submission was with regard to quashing the entire proceeding.
Yeah.
Because due to lack of sanction under 197 CRPC.
But then you have to resort to 482 proceeding.
My
Why
lord,
226?
Yes, I am coming to that. Your lordship has put me a point. I will
This is
not,
not a case for division bench.
yes, I will not suppress anything. I will place the facts because otherwise, your lordship, I will file a conversion petition if your lordship is
No,
of the.
No, you
you see that you are referring to that Bhajanlal case. Bhajanlal case, there the FIR was challenged and there it is stated that either you approach this court in 482 or you can take recourse to Article 226 and 220. That's a total different matter. Then again cognizance came. Now we are at a stage of filing the discharge petition, your petition.
Yes,
for
that
discharge.
this I had initially challenged the order of discharge, which was rejected that time because he has rejected in piecemeal manner. He has dealt with the case in piecemeal manner.
Discharge, the question of discharge came now. Where is the question of discharge at the earlier stage?
After filing of the charge sheet,
Yes,
he had kept it for the proceedings. Entire proceedings record also has been provided.
yes, that must have taken cognizance. Where is the question of
He had
discharge?
taken cognizance. Then he kept it for framing of charge. We
Yeah.
filed a discharge petition. The discharge petition was rejected, and for framing of charge, it was kept.
Which case?
In WPC number 13653
Let
of
us see, let us see.
no, there you are seeking quashing of the entire proceeding.
Yes, quashing of the proceeding.
Then the 482, you why
Yeah.
not file
Why
482?
482 and why not this? My lords, what happened? we had filed CRLMC. Your Lordship may kindly see, that is CRLMC 524 of 2018 was filed.
Yes.
For the 482 read with 397 and 401. That petition which was filed before your lordships and which was being heard, the objection was raised by the council for the vigilance that this is a case coming under the special statute. So therefore, the provision of the special statute is to file a writ and CRLMC petition is not maintainable. So that provision, that is why the CRLMC again we were forced to file a conversion petition. And that conversion petition, it was changed to a writ petition, and that writ petition has been numbered as 13653 of 2022. 13653 of 2022. The order sheets reflects, your lordship may kindly see certain provisions of the Special Courts Act which was referred to at during that time for which this conversion took place. So my stand was very clear that this was a revision. Revision will lie because it is a final order. It is not an interlocutory order. So therefore, in terms of the Prevention of Corruption Act, a revision was filed. But the learned counsel for the vigilance that time came up with this proposition that your lordship may kindly have a glance to the Special Courts Act and vis-a-vis the Prevention of Corruption Act, for which I filed.
No, now you see, Mr. Rotham, when you approach this court in that Sandhyarani case,
My lord.
that order also you are challenging the rejection of 239 CRPC.
Yes, my lords, along with the
Now-
proceeding.
So at that point of time, this gentleman, this Damodar Pradhani remained silent.
He had
He
not
did
filed.
not file.
He had not filed.
So no, we are telling that how the delay-dallying tactics has been adopted in this case. So one petition was filed for discharge of one accused. That order was rejected. Then you came to this court. Then matter kept
No,
pending.
that during the pendency, my lords, I have to explain your lordship. There is no delay on my part. The entire proceeding file has been given. He went on to discharge this petition and said for framing of charge it is came for Mr. Pradhani. In between, my lords, an interim order was passed by this division bench of this court, also staying the framing of charge. So once there is 109, he could not have adjudicated it in a piecemeal manner. So therefore, taking advantage of the situation later on, that discontinuity, there is no continuity of that order, and ACR resurfacing case, that 6 months thereafter the stay is vacated, he proceeded to reject the petition during the pendency. My lords, I have filed another petition that is WPC number 23609 of 2024. Therein I challenge the order of
There you seeking quashing on the ground that the sanction is not granted.
that along with merits.
So there are three petitions. Two petitions you are
Yes,
challenging
during the
rejection of
yes,
certain.
well, I am explaining a stand. During the
You are unnecessary wasting time.
No,
Why are you not filing proper petitions?
My lords,
See, what is
3609 of 2024 pending thila bhitare.
Mr. Rotham,
My lord.
the only thing is that this matter is can be dealt with by a single judge. As my brother has pointed out, once you file the revision, it is to be heard by a single judge.
My lords, I bow down with your lordships. But the question is, my lords, your lordship, this order is not reflected in the computer. That problem is in the net. We had filed a CRLMC. So moto conversion, for conversion again we have
You
to file.
withdraw and file it. How does it make
No,
a
that
difference?
CRLMC 524 of 2018 was filed immediately. Thereafter, the court during the pendency after 2-3 years when the matter came up, they said that this is a REIT is maintainable. The EA is not maintainable. Your lordship may kindly have a glance to these provisions under the Special Court Act. Can I place my lord's section
No,
9
it's all
of
right. You, on your oral prayer, will convert it to.
Your lordship convert it. I have no objection, but your lordship may kindly have a glance. What is the problem? That the issue has to be settled by your lordship, because whether division bench or whether single bench, these issues time and again they are raising the objection. So somebody is telling it is CRLMP. Then when the matter comes up, your lordship may see the roster. The roster special statute writ has been given to this court. So this is a local act. Under the local act, kindly have a glance at section 9.
Which roster you say?
My
You
lord,
pointed out that this is not the thing.
the roster your lordship may kindly see. That special statute writ petition କରିକି ରଖିଛନ୍ତି ଆଉ କିଛି ରଖିନାହାନ୍ତି. That roster 20.
And in my assignment, I am hearing every day this kind of
Your
petition.
lordship, I have come across your
Every day
lordship's
these
judgment.
people are
No
arguing.
arguing. I have seen your lordship's judgment,
You
reported
see,
judgment also.
Mr. Rathod,
But that your lordship,
this,
We can't have a special treatment.
which roster you say?
your lordship's roster today. I mean, the division bench
Yes,
roster.
which one?
That special courts act. Your
This
lordship
is not a special court act.
My lord.
This is not a order passed under the special court act. I have shown to you that Orissa Special Court Act something different. That is proceeding that how then you are right
that is the
this-
reason that
here the charge has been framed under PC Act.
the
and,
charge has not been fixed.
the discharge petition, the charge sheet has been filed under the PC Act and some of the offences under IPC. Is it not? Please see the charge sheet.
Yes.
So there is no offence here under the Special Court Act.
My lord, your
Special Court Act is something different. The matter may be tried by the special judge, something different. So that is a totally different proceeding.
your lordship may kindly see the designation.
Any matter which arises out of a Special Court Act,
Your lordship may kindly can I place the section. Then your lordship may tell me whether this is barred or this is not, because revision is barred. The appeal and revision is barred under section 9, subsection 2. Can I place this? Appeal against orders of special court. Unless your lordship, my lords, then your lordship will say that whether this act, which has been framed under the entry list 11, entry list 11, whether it will override the section 5.2 read with 3 of the PC Act, read with section 27 of the PC Act. Your lordship may kindly see. Appeal against orders of special court. 9.2 read with section 26. Kindly see. Notwithstanding, this starts with a non-obstantity clause. Notwithstanding anything in the court, an appeal shall lie from any judgment and sentence of a special court to the High Court of Orissa, both on facts and law. 2. Except as aforesaid, no appeal or revision shall lie in any court from any judgment, sentence, or order. Order includes final order and interlocutory order. Order, your lordship may apply the principle of justem generis, then this order of a special court. So therefore, there is a clear-cut bar so far as appeal and revision is concerned.
This is not under the Orissa Special Court Act. This is under the PC Act that
yes, my lord,
has been declared to be special judge.
Yes, then your lordship may kindly see the overriding effect, section 26 of the Act. Again, another non-obstantity clause, notwithstanding anything in the Prevention of Corruption Act 1988 and the Criminal Law Amendment Act Ordinance 1944 or any other law for the time being in force, the provision of this act shall prevail in case of any inconsistency. So this is a letter statute.
Just you are unable to follow us. Please come to section 5 of this Orissa Special Court Act.
My lord. Declaration of cases to be dealt with under this act.
Yes,
my lord. If the state government is of the opinion that there is a prima facie evidence of the commission of an offence alleged to have been committed by any person who held high office or public office in the state
high
of Odisha,
public or political office
political office
yes,
in the state of Odisha, the state government shall make a declaration to that effect in every case in which it is of the aforesaid opinion, Such declaration shall not be called in question on any.
So, in which are the cases which has to be tried by Orissa Special Court Act? Now, those cases in which the state government will declare if a person is holding high public office or high political office, then there would be a declaration and then the trial would be under the Orissa Special Court Act. Then that matter, you are right, appeal will lie. But in general, in this PC Act matter, no such declaration is being made by the state government.
My lord, that I am not aware of that fact which your lordship is stating.
You must be aware of it.
My lord, your lordship
It-
kindly have a glance at the proceeding. Annexer 7 রে সে কেমতি deal করছে। এই extract করে দিয়েছে Annexer 8 series. Can I have just one writ petition?
Do you, after reading this, do you mean to say that for every public servant, the trial should be made under the Orissa Special Court Act?
But that is under the Prevention of Corruption Act, invariably it is being
You are not following that a special judge has to try a Prevention of Corruption Act.
Corruption Act. Special
But a public servant who is high public office, holding high public service or high political office, he can only be tried under the Orissa Special Court. And for that, a declaration has to be made by the state government. Only those cases, this Orissa Special Court Act will be applicable, not for all
My lord, that clarification will also
clarification.
because
It is your case. You have to say that under section 5 declaration.
My nomenclature is being changed time and again. But I don't have any difficulty whether it goes to the single.
In your entire petition, where have you said that this declaration under section 5 has been made in your case?
My lord?
Sue me. In the writ petition,
Have you stated
anywhere
that?
stated that?
No, I have.
Then
No, I have not stated that.
Then it is an ordinary PCR case.
But will your lordship kindly have a glance at
So
the order
that means what you say, that any disproportionate asset case by any public servant that will be tried by the under the Orissa Special Court Act.
That I think the Vigilance Council can also.
No. If such a submission has been made, I am sure that this provision has not been taken into account. This Orissa Special Court Act, earlier this court was trying those cases. Just keep in mind, Justice Arijit Prasad was trying this court. I was also in many cases I was the counsel. In one case also the judgment has been pronounced, Bharat Raul case. Thereafter the virus was challenged, all these things. Then it was this new act came in 2006. Now, in view of this 2006 act case, this declaration has to be made. Only those high public offices, person holding high public offices or high political offices, and who are that is also been stated that who are those high public that is in the rule. You come to the rule, you will be getting clarified. Come to the Orissa Special Court Rules 2007. Please come to see you get yourself clarified also.
No,
Come to
yes.
Orissa Special Court Rules 2007.
My lord.
See the definition of person holding high public office.
Yes. Includes person holding a high public office, includes a public servant falling within the meaning of clause C of section 2 of the Prevention of Corruption Act or under section 21 of the Indian Penal Code, including officers of All India Service working under Government of Odisha and belonging to group.
And this is most important.
And belonging to Group A service of the center or state government or officers of equivalent rank in any organization specified in the explanation below clause 2B of section 2B who was serving under or in connection with affairs of the state government. Then high political office. My lord, he is a special secretary. So,
Counsel, again, you are forgetting that for trying an offense under this, there should be a declaration by the state government. Unless the declaration is made under section 5, there is no question of being tried by under the Orissa Special Court Act.
The rules are effective. The rules are effective.
Everything has been made effective, and there is a separate court also for that. This special court for this high ranking official, there is a separate court also totally. This is not being tried in general court. Like
my lord, your lordship is correct. Then your lordship kindly have a glance to Annexure 8 series page 149. It is stated that in the court of special judge,
CAB special judge, EAB special judge, even if जो माने ट्रायल करिवे जो
PMLA Act रे भी special court special judge
से माने SC ST भी तांकु special judge under which act that is relevant. So special judge under Orissa Special Court Act, the declaration is to be made, and the only those person will be tried for which the declaration has been made under section ଗୋଟେ ସ୍ୱତନ୍ତ୍ର ଗୋଟେ declaration ହୁଏ.
Your lordship is pointing out has not been made. Then my lord,
Then they will-
I will be tried under the special court, the special judge, the same designation, the same court.
ସେଇଟା ଗୋଟେ ଅଲଗା କୋର୍ଟ ପୁରା ଡେଜିଗ୍ନେଟ ଜଣେ ଜଜ କୁ ବିଭିନ୍ନ ଦିଆ ହେଇଥାଏ ତାକୁ ସ୍ପେଶାଲ ଜଜ ସୋ ସ୍ପେଶାଲ ଜଜ ଅଣ୍ଡର ମାନେ ଲେଟେଷ୍ଟ ସେ ଗୋଟେ ସ୍ପେଶାଲ ଜଜ ଅଣ୍ଡର ଏନଡିପିଏସ୍ ଆକ୍ଟ ଯାହାକୁ ଦିଆ ହେଇଥିବ ସିଏ ମଧ୍ୟ ଆଡିସନାଲ ସେସନ ଜଜ ସିଏ ମଧ୍ୟ ଅନ୍ୟ କୋଉ ଆକ୍ଟର ହୁଏତ ସ୍ପେଶାଲ ଜଜ ହେଇପାରେ that does not mean that once he is dealing with the NDPS Act matter means he has been declared to be a special judge under the NDPS Act. So
NDPS Act.
he is competent to try. So far as Orissa Special Court Act is concerned, unless a declaration is being made by the government, as you just now placed under section 5, that he is holding, this man is holding high public so, therefore he is declared as so and his trial will be made in that court. Only those cases will go there. And there the procedure is something different, totally different. Confiscation, how it is to be made, and what are the, in their case, appeal is to lie. That provision also you read.
Yes, my lords, that provision of section 13 to section 15, which deals with confiscation, this is a pre-trial punishment.
Don't go there. This is not under the Orissa
which is
state.
not there.
You are confusing yourself. You are trying to confuse.
But your lordship, can I
All right,
just have a glance at page when order টা ଟିକେ ଦେଖିବେ 21/12/2022 ଖାଲି ସେତିକି ଦେଖିଦିଅ ତାପରେ your lordship
Which one?
order dated 21/12/2022 ठीक page 157 of this writ petition, the first writ petition, how he has given the reasoning, the lower court below.
Which one?
Annexure 8, page 157.
Yes.
The petition under section 44(1)(c) of PML Act is filed by Assistant Director, Enforcement Directorate, Bhubaneswar, wherein and whereby it is prayed to commit the present case of this court to the Court of Special Court, Bhubaneswar, constituted under PML Act, as your lordship pointed out. As notified by the Government of India, the District and Sessions Judge Khordha at Bhubaneswar is the special court for trial of offence is under the PML Act, because here another PML proceeding is pending. According to the Learned Counsel for the Enforcement Directorate, a complaint under 45 of PML Act for offence under section 4 of the Act by complaint case PMLA number 36 of 2017 was filed against the present accused and other accused before the special court PMLA Bhubaneswar, and cognizance has been taken against it. It is submitted that since the special court PMLA took cognizance basing upon the allegation forming offence under section 13 to 13(1)(e) of the Prevention of Corruption Act 1988 read with 109 IPC, with same offences here also, which is the present case before this court, and the same being the scheduled offence under PML Act, these courts should commit the said court for trial as other than the court. No court shall try the offence basing on the non-obstantity clause mentioned in section 44(1), subsection 1 of 71 of the said Act. The Learned Counsel, in order to support his submission, has relied upon the decisions. These are the decisions which were been relied upon. Per contra, the Special PP Vigilance urged that the aforesaid details decisions relied upon by the Learned PP for ED.
Yeah, why are you placing that order? What has got relevance?
Your Lordship may see that before considering the rise of
passing the order, you file an interim application, it will go to the single.
my lord, before considering
The petition has been filed challenging the order dated so and so. After arguing for some time, the Learned Counsel for the petitioner submit that he will file an interim application to convert this writ petition to criminal revision petition, since the rejection order passed by the Learned Special Judge Special Court Bhubaneswar to the petition filed by the petitioner under section 239 CRPC is under challenge. Place this matter immediately after the interim application filed with WPC number so and so. Yes, next.
well, one interim direction, earlier interim direction will continue. The interim order passed earlier.
Which is the interim order?
That order, that appropriate application can 3 तारीख रे अछि. If appropriate application is filed, we will pass the orders. Your order,
You file it tomorrow.
your order dated
You file the
22/1,
interim, you file the
2022.
interim application tomorrow. It will be listed day after tomorrow. You'll see that. Third is very far. Yes. Call the matter, next matter.
My lord, your lordship, kindly observe that I'll file your lordship will
କହିଲି
list
ପରା ଆଉ କେମିତି?
specific direction ଦିଅନ୍ତୁ ପରଦିନ ଆସିବୁ ବୋଲି
ଆପଣ ଆଗେ interim application ଟା file କରନ୍ତୁ, କାଲି mention କରନ୍ତୁ, it will be listed day after.
ମତେ ବୁଝାଉଛି।
Yes. Next.
Item 2.
The petitioners are before this application.
My lord, another clarification, if proceeding is challenged, your lordship then
Everything can be, if you want, there are 100 decisions, Mr. Rothab. Don't, in the revision petition, you can raise every point.
limited jurisdiction.
Yes.
ସବୁ ଜିନିଷ କରିପାରିବେ।
Next.
This 480% has been filed by the petitioners. Because the lease appeal has been filed before the suppletor matter of which party approved. That has not been disposed of in certain period.
No, no, urgent required copy.
Yes.
Course of the day, otherwise I will not be able.
Yes, Mr.
Alert. The lease appeal, a separate lease, 4 lease appeal has been filed before the suppletor Baleswar. That has gone since 2023. So, directly given to the suppletor Baleswar. This was the case with the SANKAR.
The parties have already entered appearance.
Yes, madam.
You are the appellants.
Yeah.
There are, you come to Annexure 2 series,
Yes, madam.
page number 17.
Yes, madam.
It appears that there are 2 private opposite parties, Bhagwan Gupta and
Yes.
Satish Chandra Gupta.
Yes.
So whether they have already entered appearance.
Now, can you see the file the entire order sheet? From the date of filing, manner, he has mentioned in the first order.
Yes,
Yes, okay.
Learning Council draft na clear for you.
Yes, ma'am.
All right, direction date also disposal. Now, this expedition has been filed by the petitioners for a direction for early disposal of lease appeal number 235 of 2023. Pending in the court of sub-collector Balaswar. Land counsel for the petitioner submits that the case was instituted on 21/9/2023 and the parties have already entered appearance and he placed the order sheet of the case to show that the case is being adjourned several dates. The land council for the state has no objection to the prayer made in this writ petition without expressing an opinion on the merits of the case. We dispose of this writ petition directing the sub-collector Baleshwar opposite party number 2 to expedite the hearing of lease appeal number 35 of 2023 and within a period of disposal within a period of 3 months from the date of production of the certified copy of the. So the moment you produce, it will be 3 months.
Some less period, but
Parties shall not take
The parties shall not take cooperate with the court and shall not be allowed to take adjournment. Yes, what do you want?
some less period.
3 months. 3 months is
ମାନେ ବସିଛନ୍ତି ଆଉ ତାଙ୍କ କିଛି କାମ ଦାମ ନାହିଁ ଖାଲି ଆପଣଙ୍କର ଗୋଟିଏ case. One sub-collector has so many things
Yes.
to do. You will adjudicate.
Yes.
Same order in the connected cases.
Yes, yes.
The number of the cases are different.
Separate lease appeal.
अच्छा lease appeal गुड़ाक
236.
All right.
My lord,
All right, they will find out.
Yes, ma'am.
Dispose. Yes, next. Urgent certified.
Item 3.
And in the contract with the order sheet mentioned to put up on 4/2/27.
All right. ଆପଣ copy ଟା ନେଇକି produce କରନ୍ତୁ from that date. Yes. Item number 3.
Member, I think next week.
What is your good name, ma'am? You have got no power in this case. Mention is made on behalf of Ashok Kumar Sarangi ko pai apan mention କରୁଛନ୍ତି. On so on behalf of Mr. Ashok Kumar Sarangi, right gentlemen. You want it next week?
Right.
Please this matter we will comment on 3rd February 2025. All right.
Item 4.
Yes, sir.
This is the matter in which an area of 3 acres, 285 decimals were acquired and compensation were paid. But while the acquisition was taken,
Your representation is pending before land acquisition officer. Which one you want to dispose of?
the last one,
Last one means page 14.
page 14.
That is filed on 21/3/2024,
So, Lordship.
right?
Lordship, an excess area was acquired to which
So he will dispose of and pass the order within 3 months from the date of production and also communicate the order to you. Okay, and if necessary, he will give personal hearing to you. This page number 14 is your representation tachi. It is addressed to land acquisition officer. He is opposite party number 3. He is to dispose of the representation within 3 months from the date of production.
Lordship, kindly direct as per the RI report.
No, whatever you meant, we have given that you will be given personal hearing if necessary.
With your pleasure.
Yes, dispose of.
Item 5.
Yesterday, Lordship dealt with the matter, item number 12 and 13, similar matter. Lordship instructed the audit department for granting the compensation amount for the land acquisition of the petitioner for widening of river embankment and fix it for February 10th.
Yesterday, item number 12 and 13.
Yes, sir.
So, 12 and 13 में जो order है जी, तब वो notice issue है ना कौन है जी?
Notice.
देखेंगे लिख लेते हैं. Yesterday, item number 12 and 13. Okay, next.
Item 6.
Public.
Yes, Mr. Guru.
There is a mistake in my pair, so I don't place the pair number 1. Pair number 1 in page 8. There are 2 pairs. I am only confined my pair to pair number 2.
Okay. The learning counsel for the petitioner submits that the first prayer which has been made in the writ petition for setting aside the order dated 7/1/2024 passed by the additional Tahsildar Sambalpur invitation case number 5250 of 2024 is not pressed. Yes, next.
Alert the petitioner friendly is a displaced person in the Hirakud Dam project. The petitioner father was 100% displaced and he was under annexure was allotted a land. Can you have a glass to the
You earlier approached this court or first time you?
this is the first time.
So what happened to your representation which you have filed?
That has been inquired into by the,
Annexure 4 is the representation.
yes, my lord. That has been inquired under annexure 5, my lord.
Yes, then what happened?
And that is stated that now it has been allotted to the IDCO and the land has been mutated in the name of the IDCO.
Okay, no, you have not received compensation.
No, no.
Where is your averment in the petition? That the land is yours and now it has been the acquired and it has been handed over the
Paragraph 9, my lord. Paragraph 9, page 6.
10.
Paragraph 9, page 6.
Acha. So-and-so contacted as per the inquiry report, so-and-so it is found that so-and-so was allotted to the petitioner by so-and-so, but in the major settlement
Para 10 you have said.
This
In the
petition
letter
is
acquisition petition is not paid.
has again acquired from when the person has been displaced on twice in lifetime, not paid any compensation. All right, you take instruction on these two paragraphs. So the writ petition has been filed, set up letter for it, but not press has been filed by the petitioner so and so to the prayer for a direction to the opposite party for awarding compensation as per the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013 for the land acquired. Land counsel for the petitioner drew the attention of this court to paragraph number 9 and 10, wherein it is stated that this particular letter we should notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Land counsel for the state accept notice behalf of opposite parties number 1 to 4. Extra copies of the writ petition be served on the land counsel for the state. For it go requisites be filed within this week and notice be issued. Matter be placed after 4 weeks. Counter affidavit can be filed in the meantime. Yes.
Item 7.
So, like, yeah.
Item 8.
The opposite party prepare a displaced family statement of 2022. The petitioner name was not listed as the petitioner approached the opposite party and the opposite party passed for letters by annex of page 30.
What is your prayer in this writ petition?
My lords,
Quashing the letter number so and so 17/6/2022 by the project director Lower Saktel Irrigation Project Balangi, and further be pleased to consider the grievance of the petitioner sanctioned for the displaced family. Now we come to that impugned order dated 17/6/2022, Annexure 4.
my lords,
Please place that order.
my lords, the cut-off date was 1/1/22.
ଆପଣ 17/6/22 ର order ଟା challenge କରୁଛନ୍ତି ପରା?
ଆଜ୍ଞା,
Annexure 4,
my lords,
page number 30.
my lords,
So place କରନ୍ତୁ.
my lords, the petitioner filed
Food petitioner ଲେଖା ହେଇଯିବ.
my
Page
lords,
30, page 30.
my lords,
Read page 30.
application requesting for benefit of rehabilitation, resettlement and
Court
H
ପଢି ଦେଉଛନ୍ତି.
orders, my lords, page 30.
In the matter relating.
ଆପଣ ଯୋଉ order ଟି challenge କରୁଛନ୍ତି ସେ order ଟାକୁ ପଢନ୍ତୁ. ଏଇ ଏପଟେ ବାହାରି ସାରିଲେଣି ପଢନ୍ତୁ.
My lords,
ୱାକମରେ ପଢନ୍ତୁ.
my lords, orders.
ଆରି
In the matter relating to Vaidehi Behra, daughter of Bhavan Behra of village Kokhal, who has filed an application requesting for benefit of rehabilitation.
Vaidehi Behra means the
assistance.
petitioner. Yes.
Rehabilitation assistant as displaced family, verify documents as attended to the status of application Vaidehi Behra, which reveals as follow.
Hmm.
It is as certain from the copy of food orders in civil suit number civil suit March 26 of 2017 filed by the applicant herself that Vaidehi Behra, daughter of Bhavan Behra of Kokhal, got married to Ramakanta Behra of village Kusong on 7/3/2007, and as per judgment passed by the Honorable Court in the aforesaid civil suit March, the marriage of Vaidehi Behra with her husband solemnized on 7/3/2007 and got dissolved from the date of the orders 17/8/2021. In the instance case, to identify the members of extended family who have attained 18 or more years of age, son of unmarried daughter, the cut-off date as on 1/1/2017, which was further extended to 1/1/2020. had a letter number 5221 dated 19 to 2021 of DOWR Orissa was taken to as certain her eligibility. It is pertinent to mention here that as on 1/1/17 she was married, hence ineligible. She also got divorce 17/8/2021 after the cut-off date 1/1/2020. Thus, the petitioner cannot be treated as extended displaced family members as her
What is your answer to that? The
status.
cutoff date is 1/1/2020.
My
Your divorce on 17/8/2020. You are not the extended displaced family.
my lords, the
What is your answer?
my lords, the petitioner marriage 7 in 2007. After marriage of 5 years, she returned her marital house. 2012.
When you got divorced,
Divorce, my lords,
date of divorce you tell.
divorce,
As
my
a
lords, 7/8/2021.
So
Then
your
you're out.
unless till the your divorce, you are to be treated as a married lady. So you are not included within that. So the moment the divorce comes, then you could have been included, but by that time the cutoff date is already over.
My lords,
So that is the how do you meet it? As my esteemed brother has, this is the ground on which your claim was torn down.
my
How do
lords,
you challenge it?
my lords, the petitioner marriage 2007.
ଆପଣ ଏବଂ ଅନମ୍ୟାରିଡ୍ ଡଟର ପାଇଁ ଏଇଟା ପ୍ରୋଭିଜନ ଟା ଲାଗୁ ହବ କିନ୍ତୁ ମୋଷ୍ଟ ଲାଇକଲି ବୋଧେ ଯୋଉମାନେ ମ୍ୟାରେଜ ବୋଧେ ଡିଜଲ୍ଭ ହେଇଥିବ ମ୍ୟାରେଜ ଥିବ ସେମାନଙ୍କ ପାଇଁ ବୋଧେ ଲାଗୁ ହେଇଥିବ ଏଇ ଟାଇପର ଅଛି କି ପ୍ରୋଭିଜନ ଜଣେ ଆରେ ଆପଣ ଅନଉଛନ୍ତି କଣ ଆପଣ କହିବେ ନା ଆପଣ କେସଟା ଫାଇଲ କରିଛନ୍ତି ଆପଣଙ୍କର ଗୋଟେ ଗ୍ରାଉଣ୍ଡ ନେଇକିନି ଅଥରିଟି ରିଜେକ୍ଟ କରିଛି ସେ ଗ୍ରାଉଣ୍ଡକୁ କେମିତି ଆପଣ ମିଟ୍ କରୁଛନ୍ତି ଏଇ ପ୍ରୋଭିଜନଟା କୋଉମାନେ ବେନିଫିଟ ପାଇବେ ସେଟା ଲେଟ୍ ଡାଉନ୍ ହେଇଛି ଯେ ଆଇଦର ସିଏ ପୁଅଟିଏ ହେଇଥିବ କିମ୍ବା ଅନମ୍ୟାରିଡ ଝିଅଟିଏ ହେଇଥିବ ତାହେଲେ ସିଏ କଟ୍ ଅଫ୍ ଡେଟ୍ ଆରି ଭିତରେ ହେଇଥିଲେ ପାଇବେ ଯୋଉଟା କି ପ୍ରଥମେ ଥିଲା କଟ୍ ଅଫ୍ ଡେଟ୍ ଥିଲା 1/1/2017 ତାପରେ ସେଟା ଏକ୍ସଟେଣ୍ଡ କରିକିନି 1/1/2020 ପର୍ଯ୍ୟନ୍ତ ନିଆଗଲା ଆପଣଙ୍କର ବାହାଘର ହେଲାଣି 7/3/2007 ଆପଣଙ୍କର ଡିଭୋର୍ସ ହେଲା 17/8/2021 ତେଣୁ ଆପଣ ତା ଭିତରେ ଆସୁନାହାନ୍ତି ତେଣୁ ସେଇ ଗ୍ରାଉଣ୍ଡରେ ଆପଣଙ୍କର ପ୍ରେୟାରଟା ରିଜେକ୍ଟ କରିଛନ୍ତି ହାଉ ଡୁ ୟୁ ମିଟ୍ ଦିସ୍ ଗ୍ରାଉଣ୍ଡ
My lords, my lords, the petitioner filed civil suit 2017, my lords.
କଣ ହେଲା ସିଭିଲ ସୁଟ୍ ଫାଇଲ କଲେ କଣ ହେଇଗଲା ଆପଣ ସେବେଠୁ ଧରା ହେଇଗଲା କି ମାନେ ଆପଣଙ୍କର ଡିଭୋର୍ସ ହେଇଗଲା କି ଯୋଉ ଦିନଠୁ ସିଭିଲ ସୁଟ୍ ଟେ ଫାଇଲ କରିଦେଲେ ସେଇ ଦିନଠୁ ଆପଣଙ୍କର ଡିସେନ୍ସନ ହେଇଥିଲା ସ୍ୱାମୀଙ୍କ ସାଙ୍ଗରେ ଆପଣ ଆସି ବାପ ଘରେ ରହୁଥିଲେ ତାପରେ ସିଭିଲ ସୁଟ୍ ଫାଇଲ କଲେ ହ୍ୱାଟ ଏଭର ଇଟ୍ ମେ ବି ଦି ଅଲ୍ଟିମେଟଲି ଦି ମ୍ୟାରେଜ ଗଟ୍ ଡିଜଲ୍ଭ as per the order dated 17/8/2021 ତେଣୁ ଏଇଟା ଯଦି ଫ୍ୟାକ୍ଚୁଆଲ ଆସ୍ପେକ୍ଟ ଏଇଆ ହୁଏ ଆପଣ କେମିତି ଏ ଅର୍ଡରକୁ ଓଭରରାଇଡ୍ କରିବେ
Are you claiming to be a extended family member or the family member? Answer it. Are you an extended family member or a family member?
My lords, another did.
The land counsel for the petitioner, after arguing for some time, seeks for an adjournment for further preparation. Please this matter. କେବେ ରଖିବ ଆପଣ?
February.
All right. 10th February ରଖିଲେ ଚଳିବ? ଯୋଉଟା ପଢନ୍ତୁ କିଏ କୋଉ ଦିନଠୁ ତାକୁ ଡେଫିନେସନ ଭିତରେ ଆସିବ ତାର କଣ ସ୍କୋପ ଅଛି ଜଣେ ଝିଅଟି ଯିଏ ବି ବାହା ହେଇଯାଇଥିବ ସେ ପୁଣି କେମିତି ଆସିବ ତା ଭିତରୁ ଆସିବ ଏସବୁ ଜିନିଷ analyze କରି ସେ ଅନୁଯାୟୀ ground ମଧ୍ୟ make out କରିବା। Yes, next.
Item 9.
A limited prayer of the petitioner to dispose of the difference from right annex 4 page
କେବେ ଦେଇଛନ୍ତି representation? Date ତ ଜଣା ପଡୁନି। 27/8/2024 କଲେକ୍ଟର ଙ୍କୁ ଦେଇଛନ୍ତି।
The MCL land has been acquired. Open or 5 is the chief manager MCL.
He has submitted the representation to
Collector and
uh,
copy to one of the
so who will to collector. All right, opposite party number 2 to the representation and extra 5 it is to be disclosed 3 months from the production of the certified copy and the order is to be communicated to him in 2 weeks. Yes, dispose of. Next.
Item 10.
Honorable Mr. Calling, please climate control.
Mention is made on behalf of S.K.Sahoo for adjournment for specific matter in the week commencing from 17th February 2020. Yes.
Item 11. May I please? The petitioner's land has been acquired in 2002 for national highway. Till date, he has not paid the amount.
କିଛି ପାଇନାହାନ୍ତି ନା କିଛି ପାଇଛନ୍ତି?
କିଛି ପାଇନାହାନ୍ତି।
Sure, this case the NHA should be a party. National Highway Authority should be made a party.
କରିନାହାନ୍ତି, ପକ୍ଷ କରିନାହାନ୍ତି? Land acquisition officer come.
And moreover, that property that is page 17 is under the DT property, and the court directed the special directed to the authority to disburse the value of the land to the DT. So inspector endowment. So
ଆପଣ କିଏ?
My lord, it has been apportioned that the amount of the land will be given to the DT and the construction value of 2 lakhs to be paid to the 2 lakhs amount to be paid to the petitioner.
କୋଉଠି ଲେଖା ହେଇଛି?
My lord, annexure 1.
Annexure 1 ତ ଆମେ ଦେଖିବୁ value structure front to acha paragraph number 7.
My lord.
Page number 17.
My
पढ़ंतु in the result पढ़ंतु.
In the result, reference dispersed with a direction to competent authority to disperse the value of land to the deity to the inspector of endowments and the value of structure to respondent number 2 within a period of 2 months from the date of receipt of the order.
So respondent number 2 है K. Sujata Acharya,
My lord,
who is the present petitioner, right?
Yeah.
So you mean to say that that has not been paid to you?
No.
Okay.
Annexure 2 is the where this court has awarded to all the parties 12%, 30% solatium and 12% interest.
No, it's all right. So, Mr. This particular order has specifically stated that the value of the structure is to be given to him. So if you have not challenged this order, then why have you not paid? This is the order dated 12/8/2020.
This NHA will be paid.
NHA पर जो ये condition से number 2 टा देखिए land acquisition officer come a competent authority of so and so.
To receive towards the land endowment commission towards the building दवा तो NHA ताको तो कोरियर पूरी party payment has to be disbursed by the NHA.
Why are you not making the NHA party?
My lord.
Your claim is only confined to the structure or towards the land also?
No, man.
Only structure. Then NHI you have to implead. Because NHI has to pay the money, isn't it?
The or the amount has been deposited with this.
Competent authority was since long. So what happened?
তাহলে competent authority disburse করিয়ার কোন অসুবিধা আছে যদি
All the land value and structure was initially paid to the respective landowners by the competent authority. Thereafter, the review petition was filed before the sum court, which has disposed in 2009. Wherein earlier no solatium and interest was not paid to the landowners. But this is our direction of the sum court. The solatium and interest were paid to the respective party by review order passed by the sum court. Thereafter, he has all the amounts are deposited to the competent authority disbursed by the NHI. And accordingly, the respective person who have appeared and claimed that they get the benefit. Since so many days back, actually you have to competent authority has to say how much whether he has paid or not. Actually, that is NHI has deposited since 2009.
No, এইটা এবে অর্ডার হয়েছিল
Lordship has annexed that order. Review order she has annexed.
রিভিউ অর্ডারটা হচ্ছে 2009
No.
কিন্তু এই যে ଏବେ রিসেন্টলি এই অর্ডারটা ହେଇଛି ଯୋଉଟା କି the honorable justice Mishra was there at that point of time.
Yes.
As district judge Ganjam, he has passed this order.
But the reference application 3H4.
Right. So
After pursuance to this order, money has already been deposited.
I think
I think
I will take instruction because I have not I will take instruction. But I assure that
You are for NHI, Union of India.
all right, you file an application for including the National Highway Authority as a party, and you will obtain also instruction whether this particular money has been deposited or not. If that has already been deposited, then there would be no problem, right, for your dispersal. This writ petition has been filed by the petitioner K. Sujata Acharya. Inter alia with a prayer. So and so they kill it. The Land Council for the petitioner placed the order dated, a judgment and order dated 12/8/2021, passed by the Land District Judge Ganjam Barampur in SPJC number 3 of 2018. In which the reference was answered, and it was disposed of with a direction to the competent authority to disburse the value of the land to the deity, to the inspector of endowment, and the value of structure to the respondent number 2 bracket like the petitioner within a period of 2 months from the date of receipt of the order. The Land Council for the petitioner submits that in spite of the order being passed more than 3.5 years, about 3.5 years, the petitioner is yet to receive the value of the structure as per the aforesaid judgment. So appearing for National Highway Authority submits that the petitioner has not included the National Highway Authority as a party, and it is the National Highway Authority who is to make payment. The Land Council for the petitioner seeks time to file an interim application to include the National Highway Authority as an opposite party. Let the Land Council for the so obtain instruction as to whether in pursuance of the order passed by the Land District Judge in the aforesaid case, the money has been deposited with the land opposite party number 2 land acquisition officer from competent authority of so and so. Copy দিয়েছেন আপনি a copy of the writ petition be served on the Land Council for the in course of the day, and also the IA filed, and the matter be placed immediately on filing of the interim application for inclusion of NHI as of the party. Yes.
Item 12.
Single.
What do you want?
Single bench project.
This is a single bench.
Yes.
Submission is made on behalf of so and so that it is a single bench matter. The registrar shall verify and place the matter before the assigned bench. Yes.
Item 13.
Land of the petitioner was acquired by the authority for construction of lower fiscal project. For that reason, the petitioners have filed a petition under Annexure 3 for the dispute to the competent authority. But till then, that was not
Definitely.
in the similar order has been passed by your law.
It has to go to the principal judge of original jurisdiction, district judge.
এটা civil
No, civil
court.
you are district judge.
Or National Highway Authority.
Collector.
এটা জীব ঠিক আছে।
Civil judge.
Civil judge senior division.
Civil.
আদের কোন চেঞ্জ হবে খালি
খালি ডেট
না ডেট তো আছে অপোজিট পার্টি নাম্বার
না,
4
ସବୁ ସେମ୍
ସବୁ ସେମ୍ ডেট মানে এই যে
এটা 20 2/6
এটা চেঞ্জ করে দেই দিন যা চেঞ্জ চালে এটা দেখি না আগে সে ডেটটা চেঞ্জ করতে পেন্সিল দেই দাও
পেন্সিলটা করে দেই রাজি
यस ম্যাম দিস বলো
Item 14.
In my I was pattern colored say and next set of good to get marriage. Lordship has trained our lordship that annexer will be request.
which
Annexer 8C. I'm telling you.
Annexure 8 টা হচ্ছে গোটে লেখা হইছে দি copies of the notice dated
Notification আগে তো অর্ডার শিট মেলা তা সঙ্গে আছে সেটারে পেজ 111 টা ঠিক আছে 12 ଠାରୁ ଗୋଟେ ଅଲଗା ଏଲେ ଅର୍ଡର କେସ୍ ଟା ପଛେଇছে
ରିପ୍ଲେସ୍ କରିବାକୁ ପଡିବ ଆପଣଙ୍କୁ
ଆଜ୍ଞା
ସ୍କାନିଂ ହବ ସେଇ
ଆଣିଛେ ଦେଖିକି
ଆପଣ ମେମୋ ସହିତ ଫାଇଲ କଲେ
ଆଜ୍ଞା ଆଜ୍ଞା
ଲେଖିଛନ୍ତି ଏଟା annexure ଏ ୟା ଜାଗାରେ ସେଟା ସବଷ୍ଟିଟ୍ୟୁଟ ହବ ଦିଅନ୍ତୁ
ଆମ ଗୋଟେ କରିଦେଇ ନେ
ସିଲ୍ ମାରନ୍ତୁ The land counsel for the petitioner, Mr. Mishchandra Mahanti, has filed a memo with annexure 8 series for replacing the annexure 8 series. The memo with annexure 8 series is taken on record. The registry shall carry out the replacement of the documents and scan the documents filed today in court and place the matter thereafter.
Item 15.
Annexure 4 is pending. Annexure 4 page 13 before the collector.
7/3/2024 रे आपनको रिप्रेजेंटेशन किसी कम्युनिकेशन पाई ना थी
ना
collector is opposite party number
collector is
2
party number 2.
so annexure 4 is pending before opposite party number 2 collector and limit they from the date of production time this board of yes.
Item 16.
This is regarding the reserves of land by the petitioner before my lord page earlier. My lord has set aside the initial order and directed the revisional authority to reconsider and then pass the appropriate order.
Where is the earlier order?
Earlier page 29 operating part starts from page 27 annexure 5.
Fees revision case number 684 of 1987.
No.
So, what happened? You produced this order. And what happened?
Now he has rejected the same manner like your lordship has already got a order judgment. You have my lord along the sitting with your justice is fundamental. That is clearly covered. Let me insert my purpose and on can take instruction.
Come to the operative part of the order. Page number 42.
42. Like the sub-regional officer Bhubaneswar indicates mistake of fact, fraud, misrepresentation, and mislegibility of procedure. Inquiry has not been caused properly by the Tahsildar as referred on the
You are placing page number
42, madam.
here.
Better matter to page 41, para 5.
41 paragraph 5.
Madam.
All right.
ATM Bhubaneswar. The ATM Bhubaneswar had reviewed on sanction of lease by land by Tahsildar Bhubaneswar under 783 of the OGLS Act in revision case number 684/1987 and cancelled the sanction of lease land by order dated 1987, which had communicated to the Tahsildar Bhubaneswar. Accordingly, Tahsildar Bhubaneswar directed to record keeper to correct the error and intimate to the revenue inspector to take over possession of the land and report complaint. Examine the revision case record, hearing number 684/87 arising out of WF case number 1723/1973. It is found that there is so much revision on the basis of mistake of fact and material irregularities in the procedure under section 783 of the OGLS Act 1962. The case was instituted on 18/7/1987 and disposed of on 19/9/1987, giving opportunity of hearing to the lessee. Under the sanction of lease was set aside and by order dated 19/9/87, the additional district magistrate Bhubaneswar passed this order. 19/9/87, the order has been proceeded.
Please,
My lord. The sub-regional officer Bhubaneswar in this list indicates mistake of fact, fraud, misrepresentation, and material irregularity of procedure. Inquiry has not been caused properly by the Tahsildar as referred under Rule 3 of the OGLS 1974. Proclamation inviting objection has not been properly served as provided under Rule 3(5) of the OGLS Act 1974. The places and the period of the publication of proclamation are not in conformity. It has not been ascertained on inquiry if the OP is landless and if he has no other profitable means of livelihood in order to be eligible for settlement of land under the Act rules in course. In view of the above, I am the opinion that the inquiry report of the revenue inspector did not found in LCR WLA lease case number 1723/1973. It has not been ascertained by the lessee or the landless, no other profitable means of livelihood in its favor, and the lessee was eligible for settlement under Rule 3 of the OGLS Rule 1974. The settlement of the case land in favor of Surat Naik is based on fraudulent fact. Therefore, I am inclined to set aside the sanction of order dated on 29/9/74 of the Tahsildar Bhubaneswar Westland lease case number 1. So the petitioner purchased the land subsequently and is in possession of the same. The claim of the petitioner over the land cannot be accepted.
When you purchase the land?
1986.
You purchase the land from Surat Naik?
Surat Naik 1986.
କେବେ?
86.
ସେତେବେଳେ ତ ଗଲାଣି ସେ
ନାଇଁ ସେତେବେଳକୁ ମାନେ
Sorry?
ରିଲିଜ was 1973.
ହଁ
That is 14 years has to be just ସେଇ ଗୋଟେ ସେଇ ମାସରେ September 19.
no that was cancelled
In
height order
1987.
dated say 1987.
ମୁଁ କିଣିଛି 86 ମସିହାରେ ମୁଁ ଆଉ ସେ permission of the revenue authority matter. I have annexed that permission letter of that revenue officer has granted permission to for transfer of land on the application from the Surat Naik. For legal necessity of Surat Naik, the revenue officer has permitted grant permission. Thereafter, the registered deed was executed in 1986.
In the date chart, you have mentioned that you have purchased it from Surat Naik in 1986.
My lord, I have stated, my lord.
କୋଉଠି stated କଲେ ଆପଣ registered cell deed ହଉଛି 19
Annex 2, my lord.
এটা 1996 ଲେଖିଛନ୍ତି ଏପଟେ
ସେଟା ଭୁଲ, ସେଟା 87 ସେଟା ଭୁଲ, ଡେଟ୍ ଟା ଭୁଲ, 86 ଏକା।
86
ଡେଟ୍ କୁହନ୍ତୁ, କୋଉ ଡେଟ୍?
24/4 my lord,
annexure 2
my lord, Annex 2।
ଲେଖିଛନ୍ତି 19/24 ଫାଇଲ ହୁଏ
ସେଟା ଭୁଲ, my lord, my mistake, sorry।
Cell deed ଅଛି 28
ଅଠେ ଏବେ Annex that cell deed
86
page 19 180।
okay so by that time there was no problem so
problem.
he was
And
okay.
page Annex 4, page 26, the revenue officer granted permissions for execution of restored cell deed.
now then what happened just continue that order
19 September 87 is the revision order.
prior to that
Therefore, my lord, the last paragraph, page 42. Though the petitioner purchased the land subsequently and is in possession of the sale, the claim of the petitioner over the land cannot be accepted as the land was the leasehold and the lease was granted to the lessee under mistake of fact and material irregularities in account of the procedure. The revisional authority has the right while passing the order dated 19/9/87, the revision case notes so and so, and the ground taken by the petitioner has no merit, hence so and so.
so where is that lease which was granted in favor of that
That
person
document was there
Surat
for 1973, my lord.
in that WL case number 1723 of 1973
Fine.
when the lease was granted
Fine.
whether it indicates that it can be transferred to XYZ.
That I have to obtain, my lord, but the permission has been granted Annex
No,
4.
permission might have been granted
My lord,
when the lease was granted. What were the terms and conditions?
I have to obtain, my lord.
No?
I will
So
obtain.
when you purchase the land,
1986, my lord.
then permission, how in the 86 the permission is what? 1985? Before purchasing only. Annex 4.
Annex 4 is, my lord, the
Permission to sale. When is it? What's the
That
date?
is 86. 4486.
So the scheduled caste
What
land,
is the
the
date of
permission,
this?
due to the scheduled caste land, permission on 22 is mandatory, that's right.
No, that
What is
is
the
a
date?
different matter.
Date, that's
14/9,
4486.
448.
4486.
When you purchase, when you
28,
48.
okay.
That's all right, but just
only-
produce that.
Only question is there with the 73 lease deed. The 14 years, after 14 is a bar. 70, 87. So date is important to with the date of execution, say lease deed and date of cancel. If it
And
is
they say
within 14 years, then there is a.
I have informed my client.
No, another thing is that suppose even if that period is overcome, if there is a fraud or some misrepresentation has been made, then the decision says that that period cannot be hurdled.
So that's fraud, misrepresentation or in suppression.
So operation. So here that has been these are the grounds taken.
Yes.
That but you just produce that lease date.
Right.
This writ petition has been filed by the petitioner Srinirubha Das with a prayer for setting aside the order dated 12/8/2024 passed by the London Additional District Magistrate of Mishra in revision case number 684 of 1987. In holding that the revisional authority was right in passing the order dated 19/9/87 in revision case number 684 of 1987. That the there was mistake of fact or representation and material irregularity of procedure in the lease as reported by the sub-regional officer Bhubaneswar, and that the inquiry has not been conducted properly by the Tahsildar as required under Rule 33 of the OGLS Rule 1974, and proclamation inviting objection has also not been properly served as provided under Rule 35 of the 1974 Rule City Upper Ligdo OGLS Rules 1974. And it was not ascertained that the opposite party, Kontana Surat Kono? Surat Naik, is a landless person and he has no other profitable means of livelihood in order to be eligible for settlement of land under the Act and rules in force. After arguing for some time, when we asked the land council for the petitioner whether he is having the lease deed which was granted in favor of the vendor of Surat Naik, land council for the petitioner took some time to produce the same, put up this matter.
24th February.
24th February 2025. Yes.
Item 17.
In similar matter, dash matter was listed yesterday as item number 18, 19, 20, and 21.
कौन है लाल? इसको जब ये चीज
Minor issue notice.
Instruction
अच्छा तो कर 19 भी है
18, 19, 20, and 21.
क्या ऑर्डर है से आप
In the case appearing for the essence of
Yun.
for the opposite party.
and for appearance for means 2 days it was yesterday.
Item 18.
Gratefully yours. As a matter where actually a resumption case, where an order of eviction has been passed to the subject matter family. So the petitioner for also is Orient Paper Mill, which is Titagarh Paper Mill and Orient Paper Mill. You should know the oldest paper mills in Odisha. So we got these from the ex-ruler of the state way back in 1937. Two these deeds were there. Exhibit 1 and Exhibit 2, Annexure 1 and Annexure 2 are the two lease deeds. Those are perpetual lease deeds. Another lease deed was also executed, I couldn't mention because there is a matter pending, in 1974 in respect of 134 decimals, 134 acres of land.
Yes.
But altogether it comes to 837 decimal, over which the plant is existing, the quarters of the administrative quarters are existing, residential quarters are existing, and all the facilities are available, like school and everything is there. But since 2099, 2000, there was some disturbance in the factory, and the factory could not operate. But the boiler is operating, the machineries are operating, they are continuing to operate it. As it will close, then it will become rusted.
There is no production.
Right. They're trying to revive it by some other mechanism. You know, they have other factories in different parts of the country also. So initially a notice was issued for 837 decimals under Section 3B of the OGLS Act. We objected. You cannot resume the land on Section 8(3)(b). Well, after hasting actually the government has taken over. So by Section 8(1) also, I am a royal by virtue of default deemed provision of law. So what they say, they excluded the 600 decimals of land.
For 138, 3B, another notice was given. I replied to that, 3B is not applicable here. So that was a writ is filed, that writ has been admitted and stay has been granted. Notice has stay has been granted. There is a composite block, total 830. For 137, a writ has been filed, it has been stayed. For remaining part, they started this resumption proceeding, saying that we are terminating your tenancy under section 106 TP Act notice. 106 is also not applicable. So Lordship looks at the meaning wording is in the absence of any contract to the contrary, question of termination arises. Here there are two agreements are there, official agreements.
Which order you are agreed, Mr.
If Lordship kindly look at the order, resumption.
Resumption order.
Yes.
1724.
Page 40.
Page 40.
Referring to that section 111G of TP Act, and what they have found, Lacey's Orient Paper Mill has violated section Article 13. I'll read Article 13, madam. Article 13 of the agreement saying that non-observance of any of the covenant it shall allow Jamindar to right to re-enter. The OPM has violated the covenant, the lease agreement, running a planned paper mill on the lease area. On the contrary, OPM has admitted all government facilities utilize the natural sources of his operation, but ultimately is not operative since the last 20 years, keeping the lease area in vacant, not vacant, the kind, and therefore the pronounced in open court that resumption proceeding allowed. The kind look at answer 6. So this is an order that has been passed on 21 October 2024, where the boiler license has been renewed. There was no spot verification, no verification, nothing. Because they issued the initial notice, now they are sticking again to the by bifurcating the area. Okay, so order.
Is there any condition in the lease? Is there any condition in the lease?
So condition 13 can you see?
13.
But they're exactly they
Provided always. It is here by
page 25 or something.
25.
Yes.
Yes.
That is exactly I wanted to show you. They have not followed that. Provided always, and it is hereby declared that if the state yearly rent hereby reserved or a part thereof shall at any time be in arrear unpaid for the space of 3 years, next after any of the said dates, where the same shall be becomes due, whether the same shall have been lawfully demanded or not, or if there has been a duly proved, or kindly mark the word proved, duly proved any material breach or non-observance of the company of the covenant herein after contained in their part to be observed or performed them. In such case, it shall be lawful for the Jamidar notwithstanding the waiver of the previous clause of right of re-entry to enter into the upon the said premises after giving 3 months notice to the company as herein agreed. That other part is also important. The Jamidar do hereby conclude the company that the company paying the rent hereby resolves, performs all observing the covenant condition hereby contained on his part to perform, observes all or may peacefully or quietly hold, possess, enjoy the said premises. So it is a factory is there existing on the spot.
Where is the last lease? Last lease supersede the earlier leases?
So this is the annexure 1. If you look at page 22.
This last lease. That this is the latest.
It's in perpetuity.
120.
It's in perpetuity. Page 22. To hold the premises, last line. Hold the premises hereby premise into the company in perpetuity from the day of its agreement. It is registered rendering.
You are reading 22, no?
Page 22
Yes,
bottom
yes,
of the
bottom.
Page
Last.
22 bottom.
To hold the premises. Here,
Sentence to
heading.
hold the premises
Yes, perpetuity.
Yes.
in perpetuity.
So the grounds which you have taken in your expedition, please come to the you have stated regarding ground number C
Yes, correct.
that there is 106 of the TP Act is not applicable.
Not applicable. This is one of the conditions I have taken also.
You have quoted that 106.
Yes, sir. Duration of certain lease and absence of any written contract or local use. There is a contract written there, which codifies the terms and conditions. That to 111 not attracted. And there has been no field verification. The factory is
So since
existing.
there is a written contract between the parties, so therefore you say that this is not applicable.
Not applicable.
106. Then you say that there is no violation of
No
Article
violation of
13.
terms and conditions. No covenant has been violated. But the factory is existing. It's a running factory. Now it has been stopped. So maybe there is a lockdown sometimes or some defect in the factory. Can be used at any time. The factory is existing. The building is there. The machinery is there. Everything. The water license is being renewed from time to time. Factory license being renewed from time to time.
No field verification was made. What do you say, Mr.
Lordship may calculate page 38.
38? Yes.
Order dated 18/12/2023.
Yeah.
There was the district office letter dated 9/9/2023, wherein the collector Jharsuguda is directed to start a proceeding for resumption lease out common land in favor of Mrs. Oriental Paper Mills, Rajraj Nagar, district Jharsuguda. The following land is leased out. Next para. However, the open mill is not functioning since long. Further, the lease deed has been executed between Sri Mohan Rajraj Singh Deo and the Orient Paper Mills Limited, deed number such and such dated 4837, that annexure 1, and 27/137 over area such as respectively as per section 7A of section subsection 7A of section 111 of the TPI. Hence, the land is not utilized for the purpose it was leased out. So it has to be meted over the land. Agreement is there to utilize the land for specific purpose, and they are
What he says that there is no production, but the factories are working because machinery will get jammed.
That the observation in the order sheet, whether any reply to that effect, that they are further clarification on the said matter resumption of the allotted land has been received from the Revenue and Disasters Management dated 21/11/23. Issue letter to the Vice President, Orient Paper Mills, Rajraj Nagar, Jharsuguda, to submit his reply as to why this is an important matter. Why the lease out a land area 61.7179 shall not be resumed under 7A of the section 1111 of the TPI. The entire area not. The land which has not been utilized, unutilized land, not entire land. The notice was issued to reply. What reply was filed by the paper mills petitioner here to meet the query raised by the government.
So,
reply has been given. The factory is there.
Come to page 36.
Yes, reply has been given.
Page 36, para 3 and 4.
Yes, sir.
reply dela pore pora order ta pass heichi jo
Again.
That's the reply.
Before
You not consider that reply at all.
before is
So the order that is the last order.
সেটা serially নাই তো
সেটা that may come.
That is subject.
You're not.
Aro read करे.
So we'll file counter.
So you total 800 to bifurcate tale. One part was 3B re kale, eta 106 re kale. So 3B ta you stay in. Kar gote composite block 838 is.
She is only metro particular metro type of the
এই ଆପଣ reply ଟା କେବେ ଦେଲେ 7624
Right.
This order was passed on 8/12/23, which you are placing annexure 5.
Before it annexed is that.
Next set give.
नहीं नहीं ठीक है जी
no,
नहीं
date is important.
date
Annexure four.
ଆପଣ
8/12/23.
the order was passed on 8/12/2023 and later was issued to the Vice President to submit his reply. Then the reply was submitted on 7/6/2024.
Yes, sir.
That is annexure 4.
4.
That is dealt with in the impugned order at page
Then-
40. Thereafter the order.
Then the order was passed
1/7/24.
1/7/2020.
1/7.
एक साथ से.
All right.
Order sheet का total by the entire order sheet.
ये पढ़ सकते हैं जी. The writ petition has been filed by the petitioner, Orient Paper Mills, proprietor, Orient Paper and Industries Limited, challenging and resumption case number 1 of 2023, initiated by the Tahsildar Jharsuguda under section 111G of the Transfer of Property Act 1882, and the order dated 1/7/2024 passed by Tahsildar Jharsuguda in resumption case number 1
One of-
2023 by annexure 5. So also the entire proceeding of the said resumption case. The land counsel for the petitioner submitted that the authority, while passing the impugned order dated 1/7/2024, has been pleased to take into account the provision under section 106 of the Transfer of Property Act, Article 13 of the agreement However, it is the contention of the land senior advocate that the provision under section 106 of the TP Act is not applicable in the facts and circumstances of the case, as the said proceeding is applicable where there is no written contract available, but in the present case, notice itself mentions about the availability of the written contract by deed number 223 dated 8/1937 and number 15 dated 27/1/37 executed between Sri Mohan Rajraj Singh Dev and Orient Paper Limited. He further submits that there is no violation of Article 13 of the agreement lease deed warranting resumption of land, and in as much as the impugned order acknowledges that the objective of granting the lease by Jamindar to the OPM was to enable the operation of the paper mill in the larger interest of the society. He further submits that the leasehold lands were utilized for the purpose it was leased out, and there was no field verification made by the Tahsildar Jharsuguda prior to issuance of the impugned notice dated 8/12/2023. He further submits that the provision under section 111G of the TP Act is not applicable as there is no breach of any express condition of the lease. issue notice on the question of admission indicating their matter shall be disposed of at the stage of admission, and counsel for the state accepts notice on behalf of all the opposite parties. Extra copy of the writ petition be served on the land council for the state during course of the week. IN number so and so. There shall be stay of operation of the order dated 1/7/2024 passed by the Tahsildar Jharsuguda in resumption case number 1 of 2023 until further orders.
And date is
To come after 4 weeks, you file your counter affidavit in the meantime.
there is submission for us to appellate provision there under
Yes,
appellate provision.
yes, this suffers from
Applicable.
fundamental things. Yeah. You file your counter affidavit, raise that point.
Okay.
Mr. Mishra will meet it, yes. Sir.
Item 19.
Sir, my last, the thoughts in that, without considering my lease application under the OGL Act, he decided the lease application under the OGLS Act, which is violation of.
What is your prayer?
My prayer is I'm challenging the impugned order that is Annexure 9, my lord. I am a landless person and a scheduled caste person.
Annexure 9 is a, you have mentioned Annexure 9 as the copy of the order dated 11/3/2024.
My lord.
So,
That's at page 45.
but so where is that order?
That's
My lord,
45
that is
that is
45.
wrongly annexed.
And
Sankar
45
ଓ ଆଚ୍ଛା ଆଚ୍ଛା ଏଟା ଗୋଟେ କଣ ଲେଖା ହେଇଛି ଏଟା ଆରମ୍ଭ କଲା ବେଳକୁ କ୍ଲିକ୍ କଲା ବେଳକୁ ଆସୁଛି କଣ୍ଟେଣ୍ଟ ଆପ୍ଲିକେସନ ର ଗୋଟେ
ସେ contempt
Contempt.
contempt file ହେଇଥିଲା contempt initially the order that complied with then the same cause of action this situation
Good. Which page the impugn order?
My lord, that is page 45. So lordships kindly see the finding of the court, that is page 48. Finding of the Tahsildar.
Tahsildar Khurda
My lord.
has been pleased to hold that lease application of Panchu Hade.
My lord.
Panchu Hade means, who is this Panchu Hade?
My lord, the father of the petition.
Okay. So,
Moreover,
place it.
my lord, last before the last paragraph. my lord. Moreover, Tahsildar is not competent to settle the government land in urban area as per Rule 11 of OGLS rule. My humble submission before your lordship, the Tahsildar should have considered the lease case under the OPL Act, not the OGLS. If your lordships kindly see the annexure 2, my lord, of my writ application. Annexure 2, page 17.
Yeah.
The ordering person is page 20. 20. Before placing this order, my lord, I'm submitting that initially one encroachment case was initiated by the Tahsildar against the father of the petitioner.
Yes.
In the said encroachment case, the father of the petitioner filed an application to settle the land in his favor on the ground he is a scheduled caste person and a landless person. And that application was treated as a lease case number 702 of 87. When the Tahsildar, without considering that application, he started for eviction, then the petitioner filed an application, filed a writ application before this honorable court and for regarding the illegal eviction. And that application was that writ was dismissed. Against that, I prefer the writ appeal manner. In the writ appeal manner, your lordships directed the Tahsildar to consider the lease case as a under the OPL Act.
Come to that operative part of that order, which was passed in writ appeal. 9/1/2020. Page number is 20. Para 5. Yes.
Para 5.
Yes.
In view of the aforesaid statutory provision, we modified the impugned order dated 10/1/2019, passed by the London Single Judge with a direction to the Tahsildar Khurda, OP number 5, to dispose of application filed by the petitioner for grant of lease in respect of enclosed land as per provision of section 2 subsection 2A of Odisha Prevention of Land Encroachment Act as expeditiously as possible, preferably within a period of 2 months from the date of production of the certified copy of this order after giving opportunity hearing of the petitioner. However, no course of action shall be taken against the petitioner till decision is taken by the Tahsildar for that. My lord. Thereafter, my lord, the Tahsildar, without considering my lease application, he he issued an eviction notice. Against eviction notice, I preferred an appeal before the sub-collector. And the ordering of the sub-collector, that is Annexure 4, page 24, my lord. In the appeal, my lord,
24.
my lord, I prefer appeal before the sub-collector.
Yes.
And the sub-collector also stated that, my lord, if your lordships kindly see the second paragraph, my lord, in view of above. In view of above, Tahsildar Khoda is hereby directed to take suitable steps for settlement of the same in favor of the appellant as per OPL Act, if appellant is eligible and land in question is leasable in nature and also took into lease case bearing number 702 of 1987, my lord. Thereafter, my lord, when the matter was remanded to Tahsildar, my lord, but the Tahsildar did not proceed, my lord. So I filed a writ application, before this honorable court for disposal of the said remand the encroachment case, my lord. In that writ application, it was directed to the Tahsildar to dispose of that OPL case, but subsequently they did not proceed. So I filed a contempt case. In contempt case, he stated that the lease case 702 of 1987 is not traceable. So your lordships directed the Tahsildar to reconstruct that lease case regarding 720 of 87, and the Tahsildar
Page 34. Read page 34.
in result of writ petition stand disposed of with a direction to the OP number 4 to reconstruct the record in lease case number 702 of 87, accepting the relevant documents as at Annexure 3 series, and thereafter to proceed and dispose of the said proceeding as per land in accordance with law by providing the petitioner an opportunity of hearing and to complete the entire exercise preferably within a period of 6 weeks from the date of receipt of the order, my lord. But thereafter they did not proceed. So I filed a contempt case, my lord. In contempt case, they reconstruct that lease case number 720 and decided under the OGLS Act, which is violating the order passed in writ appeal. Submission before lordship. The said lease case could be decided under the OPL Act because one OPL case was initiated and I filed an application to settle the land. So he should have considered under section 7, subsection 2 of OPL Act. With lordship's permission, can I place this section, my OPL Act?
Yeah.
Read it up.
Section 7.
7.
Summary, eviction, forfeiture and fine. Any person unauthorizedly occupying land for which he is liable to pay assessment under section 4 shall be summarily evicted by the Tahsildar, and any crop or other product raised on the land, any encroachments such as a building, other construction or anything deposited thereon shall be liable to be forfeiture. Provided that in case of said encroachment, the Tahsildar shall give a reasonable notice to remove the same, notwithstanding anything contained in subsection 1 where any land is in unauthorized occupation of a landless person, the Tahsildar may, instead of evicting such person from the land in his authorized occupation, settle the same with him. So, however, the land so settled with him, together with land excluding homestead, if any owned by him and the lands owned by all the members of his family who are living with him in common mess, shall on no account exceed 1 standard acre and shall not exclude more than 1/10 of an acre of land which is being utilized or can be utilized for purpose of homestead man. So he has a power man. But without considering my lease case under the OPL Act, he decided under the OGL Act, which is contrary to the, which is violation of the
That order in passed in the writ appeal.
writ appeal. And as well as, and another point is that the Tahsildar has power under the OGL Act. But he stated that I have no power according to section 11. With Lordship's permission, I place this section 11 of OGLS Act. Rule, sorry, rule.
এই বই রয়েছে না অন্য
Rules.
Rule.
83,
My lord, 80.
section 11, sorry, rule 11.
My lord.
Circumstantial. 11, yes, 11 from 14.
My lord. Disposal of application for settlement of land for various purposes shall be made by
Just a minute, page 45. এই বই ধরছেন কি?
my lord.
Page 40.
Yes, I got it. I got it. Disposal of.
Authorities competent to dispose settlement. Disposal of application for settlement of lands for various purposes shall be made by the authorities specified in Schedule 2 up to the extent mentioned therein. All other cases for settlement of land shall be referred to the government of orders, my lord. If your lordship kindly see the Schedule 2, my lord.
Yes.
Power to sanction settlement of government land.
Yes.
Schedule 2. My lord, serial number 9. My lord. If I see in favor of homesteadless person.
No, but it says that this is not applicable for the land in urban area.
My lord, so I am placing the Schedule 2, my lord.
No, that is there.
So Schedule 2
says-
urban area रे 10 डिसमिल जदि हबो ताले सेटल करि परिबो तहसीलदार.
Not exceeding 10. Not exceeding 10 days.
Not. So here the suit land is 10 decimal. Apart from that, my lord, the Tahsildar also settled some decimal of area, part of area of the same suit land in favor of other persons, my lord, and I have
This is Bhubaneswar.
Bhubaneswar, my lord, and I have filed the ROR, my lord. That is Annex 10.
The urban area to Bhubaneswar also.
Yes, what do you say, Mr.
Here there are two things has been raised in OPLE and OGLS. The lordship may kindly, what is the application to file before this Tahsildar for settlement of land? That will under OGLS. So for OPL is concerned, my lord, it's found at the time of inquiry the person is unauthorized occupation of the land, the government land. OPL will initiate. Then in case the contention of the petition is raised that OPL Act should be initiated. The lease is not granted on OPL. 8A provision of OPL during pendency of encroachment.
Harping on that order passed by the division bench.
No, division bench that where first of all my contention, what is the application for settlement of land? That is not included. Straight away he is brought to the attention of this honorable, the order passed by the single level, then it was modified by the division bench. Then it comes to appeal is for the sub collector and OPL. What is the
enforcement in that writ appeal order? Just come to page number 19.
My lord.
Order dated 9/1/2020. there those encroachment case numbers were also mentioned.
If the encroachment cases are there,
Yes.
initiated during pendency of encroachment, there is a provision of 80 under OPLE to file application before the competent authority for regularization plan in his favor. That application is last year, there is not available. Then it on to OGLS Act. So OGLS and OPLE cannot run simultaneously.
It is an independent.
Independent. The OGLS person or landless person or agriculture for purpose, then he has to apply under the provision for settlement of land, some extent 10 decimal or 1 acre, that is under rules 11. But OPL is concerned when it is found during course of inquiry person unauthorized over the government land, then the initiation of eviction will be started. Then the form co and co, its provision is there. He has to show cause, he has to reply, then opportunity of hearing, then against their court, then sub collector order. Then in which provision he is applying? What is the application? What is the application?
Where is that application?
My humble submission before your lordship that the Tahsildar admitted in the writ application that the Tahsildar did not trace out the lease case number 702 of 87 minor. So they have lost that case minor. And after your lordship's direction, they reconstruct that lease case minor. So they lost that case minor. And my humble submission before your lordship's minor, in OPL case, I have filed an application.
Where is that application?
Not in that OGL.
Not the under the OGLS Act. And
the lease record check option is traceable, and where is the lease executed in favor of whom? The lease case of 702 of 27 in favor of whom? He can accrue right on the basis of that lease document.
Even if suppose he has power under section under rule 11 of OGLS Act, my lord, as per the rule 11, my lord, schedule 2.
Then again he is referring to OGLS.
Then when the Tahsildar has power to settle the land under the OGLS Act, he should have considered. But without considering that, he stated that
there cannot be any eviction case unless it is under the OPL. So OPL
that is the order also.
That's the division which
refers to eviction case. So and their case is that they lost that record. Now he is telling that
no, entire confusion is because of the loss of record.
But the
Genesis can't be found.
Records are indicating the finding that there is an eviction case. That was an application for these. And so OPL Act decide what is this submission?
The petition has been filed by the petitioner Puna Bhadi for setting aside the order dated 11/3/2024 passed by the Tahsildar Khurda, holding that the lease application of the petitioner would not be considered, and therefore the prayer for lease of area occurred soon 10 decimal 100 decimal out of plot number 2676 is disallowed. While passing such order, it was held that the Tahsildar is not competent to settle the government land in urban area as per Rule 11 of the OGLS Rule 1983. The Land Council for the petitioner submitted that the matter was before this court in WPC number 19437 of 2018. Wherein I had order dated 10/1/2018 19. Sorry, that order was passed.
16. 16.
No, that is in past. Wherein the order was passed. This order was challenged before the division bench in that writ appeal.
Page 90.
That the writ petition is not entertainable and accordingly dismissed. However, it was observed that the rejection of the writ petition will not stand on the way of the petitioner in raising objection involving the grounds raised before the opposite party number 4 Tahsildar Khurda for consideration of the same by the said opposite party. The Land Council submits that the aforesaid order dated 10/1/2019 was challenged by the petitioner in writ appeal number 32 of 2019, which was disposed of as per order dated 9/1/2020, and this court specifically directed the Tahsildar Khurda opposite party number to dispose of the application filed by the petitioner for grant of lease in respect of the enclosed land as per the provision under section 7(2)(a) of the Odisha Prevention of Land Encroachment Act 1972 within a stipulated time, and further hold that no coercive action shall be taken against the petitioner. From the said order dated 9/1/2020, it appears that encroachment cases were initiated against the petitioner under the provisions of PLE Act 1972. The Land Council submits then referred to Annexure 4, which is the order passed by the Sub-Collector Khurda in OPLE Appeal number 16 of 2020, wherein the Tahsildar Khurda was directed to take suitable step for settlement of the land in favor of the petitioner as per the provisions of OPLE Act 1972 if the petitioner is found to be eligible and the land in question is leasable in nature, and also look into account the lease case bearing 702 of 1987. The Land Council for the petitioner submits that in spite of the division bench order of this court, so also the order passed by the Sub-Collector Khurda in the OPLE Appeal number 16 of 2020, the Tahsildar Khurda has been pleased to hold that the Tahsildar is not competent to settle the land, government land in the urban area as per Rule 11 of the OGLS Act 1983. And he has not considered whether the petitioner is eligible to get the land under the provisions of PLE Act 1972 or not. The Land Council for the petitioner has referred to the provision under Rule 11 of 1983 rules, which deals with authorities competent to dispose of the settlement, and further referred to Schedule 2 and number 9, where it is mentioned that so far as in favor of the homestead-less persons are concerned, the competent officer is Tahsildar, subject to confirmation by the subdivisional officer if the land does not exceed 10 decimal. The land counsel for the petitioner urged that in view of such clear-cut provision under the OPLE Act, the impugned order passed by the Tahsildar is not sustainable in the eye of law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land counsel for the state accepts notice on behalf of opposite parties number 1 to 4. Extra copies of the writ petition be served on the land counsel for the state during course of the week. So far as private opposite parties number 5 to 8 are concerned, the requisites shall be filed as speed post proof of delivery within a week. Matter be listed 4 weeks after. Counter affidavit, if any, be filed in the meantime. Yes.
Passover item.
I would achieve that. I would achieve it. Just- Yes,
May
Dr. Behra.
May I please? In this writ application, the present petition challenge the illegal and arbitration action of opposite party by my lord. By whose is the present petition?
You have filed your representation.
Yes, my lord. I mean, two series, my lord.
8/1/2025.
Yes, my lord.
कौन सांगे सांग फाइल कर देले सांगे सांगे आसी आडे रिट फिट फाइल कर देले 8/1/2025 रे आपण रिप्रेजेंटेशन दैछंती से अनेकिन बसचंती केमती आपनकर रिप्रेजेंटेशन जीवो जिल्लापालकर आ किछ काम नै
नहीं आज्ञा मो जगह पूरा नहीं गले किछि आज्ञा किछि को नोटिस नहीं
तांकु टिके समय देबे ना 8/1/25 रे फाइल करिकिनी आपण संगे संगे रिट टे दरखास्त देई देबे
कौन से आज्ञा मो जगह अधा नहीं गले नहीं आज्ञा
होगला रिप्रेजेंटेशन 8/1/2025 to be disposed of in the date of production of 3 months within date of production of the certified copy. Yes.
Passover item number 7.
May I please, Your Lord? The petitioner has paid for a direction for payment of compensation package of rupees 7,72,425 along with interest. The fact of the case is like this. In Annexure 1, the Water Resources Department acquired land.
Your land has been acquired.
Yes, my lord. I am placing in Annexure 1 notification was made.
Yes.
At Mouja Chapoda. Second line of the notification, Mouja Chapoda. At page 17.
No, you have filed a representation. Annexure 7.
My name is all along in the inquiry.
No, we are asking a question.
Yes,
Your
I have.
representation is 4/11/2024.
Yes, my lord.
So, is there any communication has been made to you?
No, my lord.
All right.
Others have got
It is pending before which authority?
it could be opposite party number.
Yes.
Opposite party number.
Project director. Opposite party number 3.
Yes, my lord.
प्रकल्प निर्देशक. All right. Representation under Annexure 7. It is pending before the opposite party number 3, and it is to be disposed of side order from the date of production of the certified copy of the order. 3 months later, dispose of karibe. 2 weeks later, from taking the decision, the order is to be communicated. So
At the time of notification, she was unmarried.
Same order is to be
yes.
passed in the connected one. Both these applications were disposed of. Yes.
Item 21.
It was a formal order take. ଆପଣ କେତେ ନମ୍ବର?
ନମ୍ବର 40 ଅଛି ଯେ ଏ ବିରେମେଣ୍ଟ ଚାଲିଛି ଫ୍ୟାମିଲିରେ ସେଟା ଟିକେ 10 ଦିନ ପରେ ଆସେ
40 ଆଉ କି ଅଦର ସାଇଡ କି ଅଛନ୍ତି?
ସେଟା ସେ ଭିଜିଲାନ୍ସ କେସଟା ଭିଜିଲାନ୍ସ କେସରେ ଗୋଟେ ଥିଲା ଯେ ସେଇ ଯୋଉ ୟୁଜୁଆଲ ଅର୍ଡର ସୁବେ ଯେ ଟୁ file an adjournment petition. সেটা ଅଛି। ସେ 6 ତାରିଖ 7 ତାରିଖ ବେଳକୁ ସରିଯିବ
Where is
କାମ।
Mr. Das, Simon Das? ତାଙ୍କର ବି କଣ ଅସୁବିଧା ଥିଲା ବୋଲି କିଏ ଜଣେ ମେନସନ କରୁଥିଲା ଆଜି ଫାଷ୍ଟ ଆୱାର।
Imbue arrangement to continue.
What are you challenging here?
ଏଇଟାରେ discharge petition ତ rejection ଟା challenge। ଏଟା ଖାଲି କହିବେନି ମୁଁ ବସିଛି ମାନେ କାଲି ବି ବସିଛି ଆଜି ବି ବସିଛି।
କାଲି ତ କିଛି କହିଲେନି ଆମେ ପଳେଇଲୁ।
କାଲି ଆପଣ ଉଠିଗଲେ କିଛି କହିବା ଆଗରୁ
କହିଥିଲେ ଆମେ କରିଦେଇଥାନ୍ତୁ ଆପଣ ଆସିବାକୁ ପଡିନଥାନ୍ତା।
ମାନେ ଗୋଟାଏ ପର୍ଯ୍ୟନ୍ତ ମୁଁ ଫ୍ରି ଅଛି, ଗୋଟେ ପରେ ଯିବାକୁ ପଡୁଛି ଟିକେ।
ସିମନ ଦାସ ଅଛନ୍ତି ନା?
କହିଦେବି ତାକୁ।
Mr. Ashok Mahanti, land senior advocate, 6 for an adjournment. କେବେ ରଖିବା କୁହନ୍ତୁ?
After 7th any day.
10 ତାରିଖ ରଖିଲେ ଚଳିବ? That supplementary ପଳେଇ ଆସୁ ସୁବିଧା ହବ। This matter of 11th February 2024. Interim order ଥିଲା ଆଗରୁ।
Interim arrangement ତ ସେଇ ଯୋଉ
ଆଚ୍ଛା ସିଏ ତ ଅଛି କଣ୍ଟିନ୍ୟୁ କରିବ।
application
ହଁ ସେଇ arrangement made by this court by the order dated 21st October 2024 shall continue till next date. No? The land senior standing counsel for the vigilance department for the नाम दिलाम कौन लिखियो होगा?
The petitioner's counsel shall intimate the
let the petitioner's counsel, since this matter is mentioned out of and so on, so is not present, the land counsel shall intimate about the land senior standing. Yes, next.
Item 21.
IA for further orders. Who has filed this?
Petitioner has filed IA for amendment. I have also filed an objection.
Mr. Niranjan Panda, and there is one lady was appearing in this case.
Mr. Panda was appearing on the last date also. He was appearing.
What are they? अच्छा এটা পাস করেই থাও। Yes.
Item 22.
There are 29 appeals here.
The problem is that this bench is
Yes.
for today only.
Yes.
If we start, then that is the reason why we because it will take some time.
The dates will also satisfactory. So that will take a regular
Regular bench. Let us keep it to next week and see that.
Yes.
So,
2 PM the other bench.
2 PM the say criminal matter. So,
Can it be a lawsuit on 5th year?
5th.
Yes.
My lord, in this case, Mr. S.K. Patnaik, senior advocate, name is there. S.K. Patnaik and his associates. Name is there.
Already there is a judicial order passed by the Southern Court to delete the name of S.K. Patnaik. He is no more appearing. So already there is an order.
Names be deleted only.
କିଛି ଆମେ ଲେଖୁନୁ ଖାଲି ରଖି ଦଉଛୁ create for list this matter on 5th of February. ଏତିକି ଖାଲି କହୁଛୁ।
Yes, sir.
ହେଲା ବାକି ଯାହା ଆପଣ କରିବା କଥା କାହା କଟାକଟି ସବୁ ସେଇଦିନ କରିବେ।
ଖାଲି confusion ହଉଛି ବୋଲି।
Registry କରିବ ନା the court has already passed the order. We call registry to
5th of February
implement.
2025. All right.
Yes.
ସବୁ final disposal matter ଗୁଡାକ and it will take some time. So these are all final disposal matter. It cannot be taken out. Arising from after lunch. I'm saying the interim bail. Will it file interlocutory application? Third one, interim application for bail. Lordship has directed to list this matter in week commencing 13th June. Definitely.
Supplementary list. Item number 1.
276B and other offenses. And maximum sentence is life.
Section 302 of IPC and sentenced to undergo imprisonment for life and fine of ₹5,000.
Admit for the trial, same order, the question copy to be substantial.
Item 3.
For the trial. Rajesh Tripathi.
Item 14.
So file your reasoned affidavit.
Yes, I have. For the copy and also the report.
Okay, what are you challenging here?
I'm challenging the order of detention, yes. That is under Annex 1. And so order of confirmation.
Please place the order of detention order.
Whereas I, Anupam Prakash.
That is page number?
Page number 15.
Yes.
Whereas I, Anupam Prakash, Joint Secretary to Government of India, specially empowered under Section 3(1) of the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988, as amended, I am satisfied with respect to the person known as Nilakanta Pradhan, son of Vishnu Charan Pradhan, that with a view to preventing him from engaging in illicit trafficking of narcotic drugs and psychotropic substances in future, it is necessary to make the following order. Now, therefore, in exercise of the powers conferred by Section 3(1) of the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988, as amended, I direct that the said Nilakanta Pradhan, son of Vishnu Charan Pradhan, son of resident of village Baliapada, post
Let us see that provision. Prevention of illicit
be detailed and kept in circulation to other purpose.
Period is not mentioned.
Yes.
Final order period is
Final order.
Period is 12 months.
331.
3(1).
Page 154 of
Yes.
this book.
Yes.
Please place it.
Now, the central government or a state government, of course, I am not concerned with state government. the central government or any officer of the central government, not below the rank of a joint secretary to the government, specially empowered for the purposes of this section by that government. I'm skipping. May, if satisfied, with respect to any person.
Just a minute. 154.
Yes. Proceed.
Please 1 second.
Plus the central government or any officer of the central government.
This is the order passed by the Joint Secretary to the Government of
Yes,
India.
yes, to the detaining authority.
All right, yeah.
Not below the rank of a joint secretary to that government, specially empowered for the purposes of this section by that government, may, if satisfied, laws. I'm putting emphasis if satisfied. This is subjective satisfaction. With respect to any person, including a offender, that with a view to preventing him from engaging in illicit traffic in narcotic drugs and psychotropic substances, it is necessary so to do, make an order directing that such person be detained. Plus, clause 3. For the purposes of clause 5 of Article 22 of the Constitution, communication to a person detained in pursuance of a detention order of the grounds on which the order has been made shall be made as soon as may be after the detention, but ordinarily not later than 5 days, and in exceptional circumstances and for the reasons to be recorded in writing, not later than 15 days from the date of detention.
Okay, now grounds of detention is
plus grounds of detention was
annexure 2
from page 16. Annexure 2.
Yeah. So that starts from page number 16. It runs to 121 pages.
Yes,
sir. Up to it goes to.
Yes, with employees.
So how many cases are there against you?
Plus 3 cases have been referred here. That is page 16, you will get 1.1.
In all the 3 cases, you are on bail.
Yes.
In NCB, Bhubaneswar.
Crime number 2 by 2024. Dated 25/1/2024.
No, this case was instituted when?
2025/1/2024.
And when you got the bail order in this case?
That is was
Page 17.
Yes.
Page 17. H. Charge filed bail. H.
Thus it has not been filed. You are filed a bail application. Okay, it's a default bail then. Allowed the bail application. Charge sheet was not filed within the stipulated period, and you are granted bail.
That is page 72. That starts from page 72.
It is a commercial quantity, 21.1 kg of ganja, right? So that is one. Then next one.
Odisha excise year number.
That was also under 20B2C, commercial quantity. What is the quantity there?
30 kg.
30 kg. And there you are granted bail.
Yes, page 18.
1/5/2023.
In all this I wonder.
No, just we have to verify. Next, number 3 is the another case. It was an old case. This 2017, and that is again commercial quantity 438.2 kg, and there you were arrested on 18/9/2017. And what happened in that case? You got the bail?
Yes, no, I was on bail by the time of
No,
the detention.
that is mentioned in that order. This FIR number 108/2017. A page number 18 we are ସେଠି କ୍ୱାଣ୍ଟିଟିଟା ଦେଲା 438.2 kg. Date of arrest କହିଲା ଯେ 18/9/2017. ତାପରେ
You have not mentioned whether you
he has not mentioned whether he was on bail or not in that. I'm aware that now we come to paragraph number 3 of the same page.
are on bail.
I'm at present that you are on bail, Nilakanta Pradhan.
Yes.
However, considering your
conscious involvement in illegal trafficking of drugs and psychotropic substances in a repeated manner to the detriment of the society, you have a high propensity to be involved in the residual activities in future. para 2 is also important. After going through the facts and
What is the
circumstances,
result of this 2017 case?
that is pending trial.
Pending trial.
Okay.
That is trial.
Accordingly, the case is listed and claimed it.
Before the session,
Because
session,
7 years have already passed, that is why we asked the
The same
question.
is currently trial before the additional decision is come.
in the case of 2017, but trial is now pending for the additional session, district and session judge convert.
Kandamal both and city case number 492 of 2017. Yes.
That's, so it is sub judice. Okay, then what are the grounds? 3 cases are there. One is of the year 2017, the other is of 23, the third one, the latest one is of 2024 January.
Yes.
Right.
Case of 2024.
Huh?
Second case, Odisha Excise PR case number that is 2024.
Dita case, man?
Third case is NCP register trial number 2 of 2024.
First case.
Madam.
First case to the bala.
25 points 2024. Second case is Odisha Excise
PR
number.
PR number. Eta 20B20. Third case to 2017. Tinta the case.
Yes.
Tinta case re bail lesi acha. Yes, now you place over.
My ground of challenge for this one court is that beyond these 3 cases, the mind of the detaining authority has been swayed, and which is clear from the counter update filed by OP number 2, OP number 1 and 2, as well as OP number 3, saying that there are other cases pending against me, or I was involved in other cases, which is the reason why he has been satisfied.
Yes, that is why I asked you to place those important grounds which has resulted the subjective satisfaction of the detaining authority.
Read para 4 of the page 18, para 4.
Those are the main grounds.
Page 18. Last paragraph. In view of the facts mentioned above, I have no hesitation. Read that.
Page number 18.
Last paragraph.
Last paragraph. Paragraph number 4.
Yes. In view of the facts mentioned above, I have no hesitation in arriving at the conclusion that you, Nilakanta Pradhan, through your above facts, engage yourself in prejudicial activities of illicit traffic of narcotic drugs and psychotropic substances, which poses serious threat to the health and welfare not only to the citizens of the country but to every citizen in the world, besides deleterious effect on the national economy. The offences committed by you, that is Nilakanta Pradhan, are so interlinked and continuous in character and are of such nature that these affect security and health of the nation. The grievous nature and gravity of offences committed by you, that is Nilakanta Pradhan, in a well-planned manner, clearly establishes your continued propensity and inclination to engage in such acts of prejudicial activities. Considering the facts of the present case mentioned in foregoing paragraphs, I have no hesitation in arriving at a conclusion that there is ample opportunity for Nilakanta Pradhan, that is you, to repeat the above serious prejudicial acts. Hence, I am satisfied that in the meantime, that Nilakanta Pradhan should be immobilized, and there is a need to prevent you, that Nilakanta Pradhan, from engaging in such illicit traffic of narcotic drugs, psychotropic substances in future by detention under Section 3(1) of the Fit and Case Act, 1988. In view of the overwhelming evidences discussed in foregoing paras, details how you have indulged in organizing the illicit trafficking of narcotic drugs and psychotropic substances, as well as have a high propensity to engage in this illicit activity, it is conclusively felt that if you are not detained under Section 3(1) of the Fit and Case Act, 1988, you would continue to so engage yourself in possessing, purchase, sell, transportation, storage, use of narcotics and psychotropic substances illegally, and handling the above activities, organizing directly in the above activities, and conspiring in furtherance of above activities, which amounts to illicit trafficking of psychotropic substances under Section 2(e) of the Fit and Case Act, 1988 in future. I am therefore satisfied that there is full justification to detain you under Section 3(1) of Fit and Case Act, 1988 with a view to preventing you from engaging in above illicit traffic of narcotics and psychotropic substances specified under Schedule to the NDPS Act 1985. And considering the magnitude of the operation, the chronicle sequence of events, the well-organized manner in which such prejudicial activities have been carried on, the nature and gravity of the offense, the consequential extent of investigation involved, including scanning/examination of papers, formation of grounds, I am satisfied that the nexus between the dates of incidents and passing of the detention order, as well as the object of the detention, has been well maintained. I consider it to be against public interest to disclose the source of information at the relevant paragraphs of the grounds of detention above. While passing the detention order under the NDPS Act 1988, I have referred to and relied upon the documents mentioned in the enclosed list. You, Nirakan Pradhan, have the right to represent against your detention to the detaining authority, to the central government as well as to the advisory board. If you wish to avail this right, you should send your representative to the jail authorities where you are detained in the manner indicated below. Representation means for the detainee should be addressed to the
Okay, so this is the grounds of detention and it is on the same day.
Yes.
Okay, then what happened?
At page 127, it is confirmed by the board.
Yes.
Yes,
That is confirmed.
No, it was communicated to you on 23 to
on 4/8.
Huh?
This is 23rd 7th order has been passed.
Yes.
But I have been detained on 31st 7 2024 and on 4/8 2024 plus I have been detained. I'm sorry, I have been supplied with the grounds of detention.
Okay. Then what happened? What did you submitted your representation?
Plus I have submitted my representation, that is another one, before the jail authority. But jail authority, what they did, they have not sent it the representative to the authorities concerned, but they have said, they have in the affidavit they have stated, they have called me to the office and according to their dictation, they have said we are not sending it because it has been prepared by someone else, and as whatever we are dictating, you write it and we will send it to the authorities. And in their affidavit, the jail authorities stated we have sent it on 19/7.
19. Order was passed on 23/7. Where is it 19/7?
17/9/2017.
17.
79.
All right. So, this is the representation which you have filed. That is annexure 3.
This representation, according to you, is drafted by the jail authority.
Yes. Yes.
No.
That's what he says.
That
is
his case.
Annexure 3, which is annexed in the writ application.
Yes.
That was not communicated to the joint secretary. I'll have a glance to the annexure 3, page number 122. 126. 122. In that representation, there is no signature, no date. This is a subsequent development. This is subsequent document, created document. The representation filed by the petitioner is at annexure B/7 of the counter affidavit filed by the opposite patent number 4 and 5.
Annexure
B/7.
Counter affidavit filed by
opposite patent number 4 and 5 state.
B/7, yes.
The page 21 is the representation and it was forwarded by the superintendent of Circle Jail Chodra.
The board has confirmed on the basis of this.
Yes, my lord.
Is you ODR election?
Yes, ODR.
Yes. And you'll also kindly see the heading. And there was without sending my representation, because a copy of the representation I had with me, so what I have annexed in the petition. And now that it is done, that is a computerized prepared document and has been prepared by someone else, and that has not been given to the jail authorities. So my representation has not reached the authorities concerned.
According to you, your representation is annexure 3.
Yes.
Which was submitted through the jail
authorities,
but it was not sent to the concerned authority.
Yes,
that is your case.
Yes,
and so far as this representation is concerned, they have asked you, and as per their dictation, you have mentioned.
Yes.
That is your case.
Yes. Because
But-
they have not.
Acha, it's all right. When did you handed over this representation?
Date is same, date whatever date they are saying that was I.
No. This date is 17/9.
Yes.
What is the date which they say, according to them, that this is your really it is your representation?
79
Both date are
79 to
79.
both.
79 Purpur more actually I had given it prior to 79, but they waited for some time and they called me that it has been prepared by some other person and we are not sending it. Sorry, we will send it along with the document whatever we prepared according to our dictation. That is when they have.
All right, Mr. Kia, suppose you gave a representation and you must have been aware that whether your representation was sent or not when they asked you to write another representation. If you have
my region,
just if you have prepared this representation inside the jail, then how did you prepare it?
No, it has been prepared. My brother has taken advice of some other persons. It has been prepared.
No, you say that it has been handed over to the superintendent.
Yes, ma'am.
But it is a typed copy.
Because I have custody, I have
that is exactly they are now creating doubt that this is not actually produced. So we are also asking you, because since it's a typed copy and you are inside the jail, so unless this type of type machine is provided to you inside the jail, you could not have prepared all this. And it contains all the legal terms. So it appears that it was prepared outside.
Yes.
Okay. So if it was prepared outside, have you taken any ground that it was prepared by Mr. So and so, my brother?
No, that is not.
And it was handed over to me.
No, that
and the jail gate, I produced it before
that
the
is
jail.
not mistaken.
No, even if it is prepared by outside, if all the grounds are taken, what is your grievance? How are you prejudiced?
Whether that
Because
is
you are
permissible, that is
just
only
see,
question decided whether that is
no,
permissible or
no,
not.
you see your representation. You have written in Oriya 3 lines. And the representation which is supposed to be placed before board is an exhaustive one, taking all the grounds. How are you prejudiced?
No, because I'm prejudiced. Here, because only question I pray by your lordship to decide whether a representation prepared by a friend outside the jail, because I am there in custody.
If all the grounds are taken, then there is no illegality.
No,
whether that can be taken into consideration, whether that should be sent at least to the advisory board.
If it is prejudicial to you, then only. If it is, he has taken care of every grounds which you have not raised, then it is not prejudicial.
Where is your ground?
That is my secondary point, sir. That is my secondary point. I will come to the latter block. That is my second. My primary point is somewhere else.
You come to the primary point.
Yes. My primary point is the grounds plus whatever your lordship has found in the ground. There are 3 grounds. But in the counter evidence they have come up with, and I have taken the ground of malafide, because the authority, detaining authority has acted according to the dictation of the sponsoring authority. According, because their counter himself has stated that I am taking the assistance of the sponsoring authority to file the counter affidavit. Because I am taking the lordship that time. That is was counter of OP number 1 and 2. It is a copy of the counter filed by the OP number 3.
Have you specifically mentioned in the writ petition that these are the grounds on which I am challenging the?
Yes, I have specifically mentioned the ground.
Which are the paragraphs? Which are the grounds? Let us see what are your grounds, because that must be also mentioned in the writ petition.
I am now because after finding the counter affidavit, when I found that my representatives have not been sent to the authorities, then I have in my agenda I added the second ground. But the first ground here is paragraph page 7.
Let us see your ground.
Page 7.
Yeah.
Therefore, last paragraph. It can be safely stated that the order of detention can be said to be an outcome of the malicious move of the sponsoring authority. The OP number 3. The detaining authority, the OP number 2, without applying his mind, has been biased with the report of the sponsoring authority so as to pass the order of detention in the garb of subjective satisfaction. This is my principal ground loss. And that has been lost substantiated by the counter affidavit filed by OP number 3 and source of the counter subsequently filed by OP number 1 and 2.
What is there in annexure 4? You say that it is biased one.
Yes.
You said in that grounds. Just read it also.
That is confirmation.
You impute malafide against respondent number 3.
Yes. That was illogically come to. That is very important.
Which para?
Counter OP number 3, you'll also find at flag A.
Yes, para.
Paragraph 13 loss. Internal page 19. That is that the contentions made in paragraph 13 of the writ petition are vehemently denied as being misconceived, devoid of merit, and untenable in law. It is respectfully submitted that the detaining authority has passed the detention order under section 3(1) of Prevention of Illicit Traffic in Narcotics and Psychotropic Substances Act 1988, P10 Act, after arriving at a well-reasoned and justified subjective satisfaction based on credible and cogent material. Next, that is important. The detaining authority has found sufficient reasons to believe in the propensity of the petitioner's criminal activities, which span a period of nearly 2 decades, from 2005 to 2024. During this period, the petitioner has been behind bars at least 8 times for his involvement in various crimes. Apart from the 3 NDPS cases cited on the grounds of detention, the petitioner is also implicated in 3 cases under the Excise Act and 2 additional cases under the Indian Penal Code. At continued engagement of petitioner in such activities,
yes.
Even
these additional cases are not the ground of detention.
Yes, these are not be supplied to me.
Yes.
And plus, here, OP number 3 is the sponsoring authority. Now, your aspect I'll come to.
No, you leave it, just go on. How to give
Yes.
You chaditile podon.
The continued engagement of petitioner in such activities, even while being enlarged on bail, establishes a clear pattern of persistent and organized criminal conduct. It is further submitted that normal laws have been found insufficient to prevent the petitioner, Nilakant Pradhan, from engaging in the illicit trafficking of narcotic drugs and psychotropic substances. The conscious and repeated efforts of the petitioner to traffic and supply illicit drugs pose a serious and imminent threat to the health and welfare of the society at large. His activities have had a deleterious effect on the younger generation, particularly in the state of India, and such actions cannot be neglected or ignored. You will also not find from the 3 grounds even whatever has been given. The subjective satisfaction of the detaining authority is based on the cumulative effect of the petitioner's repeated offences, the organized nature of his activities, and the significant potential harm they pose to society. The magnitude of his crime cannot be judged in isolation, but must be seen as a clear and continuous effort to disrupt public order and welfare. Therefore, the detention of the petitioner under P10 Act is not only reasonable, but also imperative to prevent further engagement in such illicit and dangerous activities. Well, the reasons of bringing this act into operation that has been stated in that particular act also, just that has been stated here. There's nothing to show that the activities of the petitioner had a deleterious effect on the younger generation. For a moment, I humbly pray Lordship to come to P10 Act. The purpose, the act has been brought to...
Just to take pause for a moment. So, Mr. Counsel from the, he has just now placed this counter affidavit which has been filed by the opposite party number 3, and page number 19, paragraph number 13. And there it is mentioned that those 3 cases which have been mentioned in the grounds of detention, that of
There are few
what
other
prompted the authority to pass the detention order is also that he has been implicated in 3 other
Other-
Excise Act cases, 2 additional cases under IPC. And you cannot dispute that the details of those cases have not been furnished to the petitioner because the grounds of detention has been placed. And in the next page, that is page number 20, in the middle part, it is mentioned that the subjective satisfaction of the detaining authority is based on cumulative effect of the petitioner's repeated offense, the organized nature of
2005 to 2024.
of his activities and the significant potential harm. So let us say you have considered 8 or 9 cases and passed the detention order, but you have intimated to the petitioner only about 3 cases. So if you would have not considered those 5 cases, which has not been communicated, you might not have reached that satisfaction to pass the order of detention. It is the cumulative effect of all the 8 cases that resulted in the subjective satisfaction of the detaining authority. If it would have been 3, you might not have thought of passing the detention order.
In the detention order, 3 cases have been mentioned. The counter, we have said that there are other cases also for which the petitioner has been implicated.
So those things were taken into account by you while passing the detention order.
No, only on 3
You
cases.
have not reflected it in the order, but you have taken into account because your counter is very clear.
Yes.
Your detention order has been passed because you think that there are 8 cases, right?
No, detention order, there are 3 cases.
No,
you are not following.
Subjective satisfaction for that.
See, for the purpose of arriving subjective satisfaction, you have to place the material before the detaining authority. The material which you place before the detaining authority, the same thing has to be communicated to him. What is his case is 3 cases were placed before the detaining authority, whereas you are improvising in the counter affidavit, saying that there are many other cases spanning from 2005 to 2024. Have you placed those things before the detaining authority, or you are trying to justify in the counter?
We are trying to justify in the counter.
That is his case.
And the counter filed by option number 1 is
kindly see the prayer. They are challenging on a different ground. It's challenging on a different ground. That there is not 5 weeks within the 5 weeks period. The advisory board has not been placed. The case is that. Now my learned senior is improvising the case, saying that there is a 5
Because
weeks.
you improvise in the counter, so therefore in the rejoinder he improvised his case. It is a detention case.
It's a detention.
He has right to change the grounds.
But the sole question is whether it is within the parameters of the act that is being provided. Within 5 weeks, we have advisory board has been placed and it has come not, because they are challenging to 23/7 to 31/10, 18/10. But that's not the case. The case is on 3/9, the matter was placed with the detention board. They are not challenging on the ground that.
I'm giving an example.
Mal.
Suppose a bail application is argued, okay, and the objection is raised by the state council that the petitioner is involved in other 2 cases.
Yes,
and
that's
those
what I
2
mean.
cases are sworn.
My lord is correct.
So we may say all right, 2 cases, but when you say that the petitioner is involved in 20 cases, then we may have it's a habitual offender, so we may reject the application.
That's on record that I.
So while passing the order, you are taking into account 8 cases. Your mind is that there are 8 cases. But what you are mentioning is the order. You are mentioning only 3 cases. So if at that point of time, let us say those 5 cases would not have been there. Well, it is there. Let us say it is there, but it is not there. Then on the basis of those 3 cases, you might not have thought of passing a detention order. You pass the detention order because in your mind it is there that there are 8 cases.
No, at the time of passing the detention order,
No, you are not following.
State has no
3 cases, my
You are not following the.
My lord is
ଆପଣଙ୍କ ପାଖରେ ଯେତେବେଳେ detention order pass କଲେ ଓଡ଼ିଆରେ
passed by the object fact number 1.
ଯିଏ ବି pass କରୁ detention order pass କଲା ବେଳକୁ authority Who has passed the detention order?
Opposite part number 1. And this
So-
counter affidavit is filed by the sponsoring authority. The opposite part number 3.
So the information, who has given the information to the detaining authority?
Opposite part number 3 regarding 3 cases.
सेई ऑर्डर को बेस करिकिनी से रेकमेंड कले तो
Yes. Opposite part number 1 pass the detention order.
बाबू स्पॉन्सरिंग कले किए
Opposite part number 3.
क्लियरली बुझंदु अपोजिट पार्टी नंबर 3 जते बेले स्पॉन्सर कले कोन पई स्पॉन्सर कले जे लोकटा नारे 8टा केस अछि मुंडे तांकर सेया रहिला
किंतु स्पॉन्सर कलल 3टा केस विषय
3टा केस रिफ्लेक्ट कले से जो जदि स्पॉन्सरिंग अथॉरिटी वुड हैव बीन फेयर एंड स्पॉन्सरिंग अथॉरिटी करो जदि मनरे थांता जे एक्चुअली तानार 3टा केस अछि ताले दे वुड नॉट हैव स्पॉन्सर्ड फॉर डिटेंशन ऑर्डर.
Your submission makes your case worst. You say that the sponsoring authority has not placed material before the sanctioning authority, relevant material before sanctioning authority. Sanctioning authority has to arrive at a subjective satisfaction. On the basis of what? On the basis of 3 cases.
3 cases on narcotic substance.
That is his case. Then it's difficult for you to justify that.
And so far the representation is concerned, my lord, ample opportunity was given to the petitioner. You can have a glance to chapter B6, page 16 of counter affidavit filed by the opposite party number 4 and 5 at page 16.
Page 16.
Yes, my lord. It was addressed to the petitioner.
Just a minute. Yeah.
Tapara, so the advisory board, NDPS Odisha has decided to again sit on 20th September 2024 at 5:30 p.m. in the Circuit House, Cuttack, and directed to notice the detainee Nilakanta Pradhan currently detained at Circle Jail Chaudhar, Cuttack. If he desires to be heard in person before board and desires to submit any representation, you are intimated to submit any representation if desires so within a week. That is on or before 17/9/2024. Therefore, detainee Nilakanta Pradhan is hereby queried that do you desire to heard in person before advisory board PTNDPS Cuttack? Answer yes. Do you desire to submit any representation to the above cause? Answer yes. Nilakanta Pradhan signed on 11/9/2024. Thereafter on 17th. Annexure B7, page 20, relevant 21 is the representation, and on page 20 it was forwarded by the superintendent to the board member.
So then this petitioner must have also appeared also
Yes,
before
yes,
the
physically appeared.
So
before the board.
There, did you raise any complaint? That's the representation which is before you, my representation. That is not the proper representation. I have this representation which I have submitted before the authority, and that was not forwarded.
No, that only record
That record is.
But hearing this is recording officer. And what concern with it?
Technically representation of
Representation.
Yes, you argue.
Yes, sir. The doctor can come to flat C, the counter filed by OP number 1 and 2. It is more devastating. Lawsuit come to paragraph 7. It is submitted. Paragraph 7 goes. It is submitted that the present counter affidavit has been prepared in consultation with the sponsoring authority, that is the Zonal Director Narcotics Control Bureau, Bhubaneswar, Odisha. Well, subjective satisfaction of the detaining authority, but he has to consult the sponsoring authority to file the counter affidavit. That itself suggests that person has not applied his own mind, rather has acted according to the mind of the sponsoring authority. And paragraph 13 at page 12 was.
is a reproduction of the affidavit filed by OP number 3. For 13, page 12, that the detaining authority has found sufficient reasons with subjective satisfaction against Nirakant Pradhan with regards to the propensity of his crimes since the year 2005 till 2024, wherein the detainee has been behind the bar at least 8 times as he was involved in various crimes. Apart from 3 NDPS cases against his name, the detainee has also 3 cases under Excise Acts and 2 more cases under the Indian Penal Code. It was submit that detainee was, while enlarged on bail, had continued then. And last line.
How you came to know about the 8 cases? You are filing this 1 and 2. You are.
Yes.
So they have intimated to you about 3 cases.
Yes,
How you came to know about the 8
these
cases?
3 cases we are saying, we're going to say that 3 cases of P20 and other cases of IPC and other things.
The council don't, the order is you have seen the grounds of detention.
Yes.
Nowhere it is mentioned that apart from these 3 cases, which numbers have been given,
Yes, ma'am.
there are any other case. Is it there?
No, it is not.
So if it is not there, you get this information that there are 3 cases. Now, how you are filing the counter affidavit in which you are mentioning that apart from the 3 cases, there were other 5 cases.
Other cases of IPC.
What is your source of?
We mean to say that I should be fair with the honorable court to say that 3 cases of P20 case, other cases are
that you have, that is not
very
mentioned.
basis. Yes.
That the sponsoring authority actually not indicated to you. So it is obvious that after getting this counter affidavit, you just made the copy paste of that.
Yes. The counter affidavit filed by OP number 3, that is on 21st January 2025, and by OP number 1 and 2 on 6/1/2000. Sorry, OP number 3 on 6/1/2025, and OP number 1 and 2 on 21st 1/2025, after 15 days. Sorry, beg pardon. Okay, sorry. We'll have to read this.
Yes. Any other point?
Well, next point, that is regarding the representation, sending of representation. That is very controversial. Of course, I don't want to go to that one. I confine my point to this part only. Because the grounds under which the subjective satisfaction has been arrived at by the detaining authority has not been supplied to me.
And not placed before.
And there are so many judgments of the office court. Exactly. You actually get the point from that. That is Rameshwar Shaw versus District Magistrate. Come to paragraph 4. The point is in the middle, but I'm waiting for the very beginning. Mr. Garg or the petitioner has challenged the validity of the petition detention several times. He contends that the detention of the petition is not justified by the provisions of Section 3(1) of the Act and as such is invalid. He also objects that the order of detention has been passed against the petitioner that the district must be Budwan, Mala fact. According to him, the Mala material facts stated in the notice served on the petitioner setting forth the grounds for his detention are imaginary and non-existent, and some of the grounds are vague and irrelevant. And he also contends, plus CM was putting emphasis on this fact, and he also contends that the affidavits filed on behalf of the respondent clearly indicate that some of the grounds on which the detaining authority relies and which must therefore have weighed in his mind at the time when the detention order was passed were not disclosed to the petitioner when the notice of grounds was served on him, and that makes the communication of the grounds materially defective. It also affected the petitioner's right to make an effective representation. Even if I have not given a representation, that will not have my case.
What is the, this is the submission was made.
This
What
is
is
the
the,
that submission has been accepted. And I'm reading the entire paragraph. These infirmities in the notice says make the order of detention invalid. It has also been suggested that the petitioner was in fact denied an opportunity to make his representation to the advisory board, and that also introduces an infirmity in the order. Since we have come to the conclusion that the first contention raised by Mr. Garg is well founded, we don't propose to consider the merits of the other argument or by him in support of his petition. And accordingly, basically on that, and
in this line, there is a judgment of Justice Samant.
Yes,
you have that judgment.
In this case, that means there is no discussion on this particular.
Yes, that is it.
No.
It is.
Paragraph 8. It is have necessity to emphasize.
Is you descendant?
Say descendant to
Paragraph 8.
Paragraph 8 and 10. It is have necessity to emphasize in this connection that the satisfaction of the detaining authority contemplated by Section 3(1)(a) is the subjective satisfaction of the said authority. Cases may arise where the detainee may challenge the validity of his detention on the ground of malafides and in support of the said plea, or that along with other facts which show malafides, the court may also consider his grievance that the grounds served on him cannot possibly or rationally support the conclusion drawn against him by the detaining authority. This part is important. It is only in this incidental matter and in support of the plea of malafides, this question can become justiciable. Paragraph 10. In this connection, it is however necessary to bear in mind that the past conduct or antecedent history of the person on whom the authorities purport to act should ordinarily be proximate in point of time and should have a rational connection with the conclusion that the detention of the person is necessary. It would, for instance, be irrational to take into account the conduct of the person which took place 10 years before the date of his detention and say that even though after the said incident took place, nothing is known against the person indicating his tendency to act as in a prejudicial manner. Even so, on the strength of the said incident, which is 10 years old, the authority is satisfied that his detention is necessary. Here they are saying 2 decades, for 2 decades process in law. In other words, where an authority is acting bona fide and considering the question as to whether a person should be detained, he would naturally expect that evidence on which the said conclusion is ultimately going to rest must be evidence of his past conduct or antecedent history which reasonably and rationally justifies the conclusion that if the said person is not detained, he may indulge in prejudicial activities. We ought to add that it is both expedient and undesirable to lay down any inflexible test. The question about the validity of the satisfaction of the authority will have to consider the facts of the detention of person without trial is very serious encroachment on his personal freedom, and so at every stage, all questions in relation to the said detention must be carefully and solemnly considered. Hence, at this stage, whilst looking at the counter affidavit, also your lordship can consider whether the order of detention is illegal or not.
No, on this particular point, have you got
Yes,
any
Khudiram
direct
Das,
decision
Khudiram Das versus State of West
that,
Bengal.
let us say that some of the grounds on which the detaining authority relies and which must have weighed in the mind
Yes.
at the time of detention order,
Yes.
these 5 cases,
Yes.
extra
Yes.
5 cases that were not disclosed to the petitioner
Yes.
in the when the notice of grounds or so and so, and that makes the communication of the grounds materially defective.
Defective.
এই পয়েন্টে ডাইরেক্ট ডিসিশন
Yes, yes, very time. That is Khudiram Das versus State of West Bengal. Because of course, I could not get the printout because net was not available. Otherwise, I could have get. Khudiram was the third one. And Poppu is the judgment of our of this unquote. Well, I'll get the printout and give it.
এটা কোনটা?
Khudiram.
Khudiram. এই প্যারাগ্রাফটাকে আসুন যোগ্য পয়েন্ট দিয়ে লিখছি।
Para 4, 5 and 6. Before that, I'm reading paragraph 3. The petition was presented by the petition from jail, and since he was not represented by the council, his court appointed Mr. R.K. Jain amicus curiae to present the case on behalf of the petitioner. Mr. R.K. Jain, on behalf of the petitioner, all the following grounds against the validity of the order of detention. It is apparent from the grounds of detention furnished to the petitioner that there were only 3 incidents of theft on which the district magistrate relied for the purpose of coming to a satisfaction that it was necessary to detain the petitioner with a view to preventing him from acting in any manner prejudicial to the maintenance of supplies and services essential to the community. These 3 incidents were objectively not sufficient to justify such satisfaction, and the order of detention based on such satisfaction was therefore bad. In view of in the view taken that the power to detain a person could be exercised by the detaining authority merely on its subjective satisfaction, which could not be tested with reference to the objective standards, Section 3 of the Act, which empowers the detaining authority to exercise the power of detention on the basis of the subjective satisfaction, imposed unreasonable restrictions on the fundamental rights of the petitioner under Article 19(1) and was therefore authorized that article. C is important. The history sheet of the petitioner was before the district magistrate when he made the order of detention, and though the district magistrate stated in his affidavit in reply that beyond the 3 incidents mentioned in the grounds of detention, he didn't take any other material it is in a other way. He didn't take any other material in the history sheet into account in passing the order of detention. It was impossible to say that he was not influenced by such other material, and since no opportunity was given to the petitioner to make an effective representation against such other material, the order of detention was in contravention to.
In that case, he says that we have not taken into consideration.
Yes.
Taken into consideration.
If you also give another chance,
makes the case worse.
And paragraph 5, we'll first consider the constitutional background against which the Act has been enacted, and then refer to the material provisions of the Act. The relevant article of the Constitution having bearing on the question is Article 22. This article has been analyzed in more cases than one by this court, and it is clear from the decided cases that this article provides various safeguards calculated to protect personal liberty against arbitrary restraint without trial. These safeguards cannot be regarded as substantive. They are essentially procedural in character, and their efficacy depends on the care and caution and the sense of responsibility with which they are regarded by the detaining authority. 2 of these safeguards, which relate to the observance of the principle of natural justice and which is a fortiori, are intended to act as a check on arbitrary exercise of power, as is found in Article 22(5) of the Constitution. This provision of Constitution introduces 2 procedural requirements embodying the rule audio and pattern to a limited but a crucial and compulsive extent by providing that when any person is detained in pursuance of an order made under any law providing for the preventive detention, the authority making the order shall, as soon as may be, communicate to such person the grounds on which the order has been made and shall afford him the earliest opportunity of making a representation against the order. The constitutional imperatives enacted in this article are twofold. The detaining authority must, as soon as may be, that is, as soon as practicable after the detention, communicate to the detainee the grounds on which the order of detention has been made. And two, the detaining authority must afford the detainee the earliest opportunity of making a representation against the order of detention. These are the barest minimum safeguards which must be observed before an executive authority can be permitted to fervently detain a person and thereby drown his right of personal liberty in the name of public good and social security. But what is content of these safeguards? What does the word grounds mean? Does it mean only the final conclusions reached by the detaining authority, on which alone the order of detention can be made? Or does it include the basic facts and materials from which the conclusions justifying the order of detention are drawn by the detaining authority? What is the interrelation between the requirements of the first and the second safeguards? Is the efficacy of the second safeguard violated by non-observance of the requirement of the first safeguard? If all the grounds which weighed with the detaining authority are not communicated to the detainee, does it constitute merely a breach of the first safeguard, or does it also involve the violation of the second? 6 laws. The answer to these questions doesn't present any serious difficulty if only we consider the reason why the grounds are required to be communicated to the detainee as soon as may be after detention. Obviously, the reason is twofold. In the first place, the requirement of communication of grounds of detention acts as a check against arbitrary and capricious exercise of power. The detaining authority cannot whisk away a person and put him behind bars at its own sweet will. It must have grounds for doing so, and those grounds must be communicated to the detainee so that not only the detainee may know what are the facts and materials before the detaining authority on the basis of which he is being deprived of his personal liberty, but he can also invoke the power of judicial review, however limited and peripheral it may be. Secondly, the detainee has to be afforded an opportunity of making a representation against the order of detention. But if the grounds of detention are not communicated to him, how can he make an effective representation? The opportunity of making a representation would be rendered illusory. This is one answer loss. The opportunity of making a representation would be rendered illusory. The communication of the grounds, grounds of detention is therefore and also intended to subserve the purpose of enabling the detainee to make an effective representation. If this be the true reason for providing that the grounds of which the order of detention is made should be communicated to the detainee, it is obvious that grounds mean all the basic facts and materials which have been taken into account by the detaining authority in making the order of detention and on which, therefore, the order of detention is based. To quote the words of one of us, this is Zakaria, in Ghulam Malik versus State of West Bengal, in the context, ground doesn't merely mean a recital or reproduction of a ground of satisfaction of the authority in the language of Section 3 of the Act, nor is its connotation restricted to a bare statement of conclusion of fact. It means something more, that something is the factual constituent of the grounds on which the subjective satisfaction of the authority is based. The basic facts and material particulars, therefore, which are foundation of the order of detention, will also be covered by grounds within the contemplation of Article 22(5) and Section 8 and are required to be communicated to the detainee unless their disclosure is considered by the authority to be against the public interest. This has always been viewed consistently taken by this court in a series of decisions. It is not necessary to burden this judgment with citations of all the decisions. It will be sufficient if we quote the following observations. Justice Patanjali Shastri in Ramkishan Bhardwaj State of Delhi. The petitioner has the right under Article 22(5) as interpreted by this court by a majority to be furnished with particulars of the grounds of the detention sufficient to enable him to make a presentation, which on being considered may give relief to him. We are of the opinion that this constitutional requirement must be satisfied with respect to each of the grounds communicated to the person detained. Justice Venkatramaya also pointed out in Samara Vishnu Parulekar versus DM that constituting the words grounds on which the order has been made in their natural and ordinary sense, they would include any information or material on which the order was based. The Oxford Concise Dictionary gives the following meanings to the word ground: base, foundation, motive, valid reason. On this definition, the materials on which the district magistrate considered that an order of detention should be made could properly be described as grounds therefore. It is therefore clear that nothing less than all the basic facts and materials which influence the detaining authority in making the order of detention must be communicated to the detainee. That the plain requirement of the first safeguard of Article 22.5. The second safeguard in Article 22.5 requires that the detainee shall be afforded the earliest opportunity of making a representation against the order of detention. No avoidable delay, no shortfall in the materials communicated shall stand in the way of the detainee in making an early yet comprehensive and effective presentation in regard to all basic facts and materials which may have influenced the detaining authority in making the order of detention depriving him of his freedom. These are the legal bulwarks enacted by the constitution makers against arbitrary or improper exercise of the vast power of preventive detention, which we vested in the executed by law of preventive detention, such as Maintenance of Internal Security Act 1971.
So, what the point he is raising, it is, if we come to the short, that the sponsoring authority or the detaining authority, they, from this affidavit which has been filed, it appears that they have taken into account the during the period of 2 decades, 2005 to 2024, that there are 8 number of cases against the petitioner. So please,
yes, that is my point.
Just a minute. Apart from those 3 cases of NDPS, there are other cases, excise act cases, and Indian Penal Code. So this cumulative effect of all these cases has resulted in the subjective satisfaction of the detaining authority. That is very clear from the.
It's a little different, Your Lordship, it permits. Whether those 3 cases are also sufficient for detaining this person is not.
No.
That is in
question
counter. You are
is,
citing there the other cases are there.
no,
but
you
the
cannot
question
segregate
is,
that. The question is that if your subjective satisfaction is based on 8 cases, whether you are required to indicate it, furnish it to the petitioner, or withhold the information.
May I pose a question to myself, Your Lordship, whether those 3 cases are also important or necessary or maybe a ground to detain the person?
Minus 5 cases, it might not have been, that is exactly from the first point of time, minus those 3 cases, minus those 5 cases, on the basis of these 3 cases,
but
you might not have reached that satisfaction.
Your Lordship, that is never the case.
What he is trying to say is,
yes, I understand.
The ground of detention. What is a ground? Ground means any fact or a material which influences the detaining authority to pass the detention order is a ground.
Yes.
And the fact that there are 8 cases, this is a fact that weighed in the mind of the detaining authority to pass the detention order.
It is in counter.
And that was not placed before him.
No,
the ground was not supplied.
I the same question if I pose to myself whether those 3 cases are sufficient enough.
No.
Maybe sufficient. Maybe sufficient.
Maybe
sufficient.
That's my point.
But how will you sustain a detention order without
detention order has been passed earlier? This is a counter. We are saying that the person is an habitual offender.
That is what he says. That's the ground that is weighed in the mind of detaining authority to pass that order.
On the counter, the writ cannot be developed. Your Lordship, the writ they have already filed on a different count. Now on the counter, some point has come that there are other cases also. Now he is giving in a rejoinder. But the thing is, when the writ was filed, or when the question of whether the detention is legal or illegal, at that point of time, these questions are not there. Because we made some amendments only to refer that the person is involved in other crimes.
You have mentioned only on the basis of 3 cases.
Yes,
in the detention order. But in fact, your mind is influenced not only by these 3 cases, but other 5 cases.
Other cases might be there.
No question of might have.
Or is there.
You cannot withhold the information. Land Council, you cannot withhold that information. Whatever influenced your mind,
that has to be given.
That is to be given to the.
This is for the.
That's the ground.
This is to bring
whether these 3 cases are sufficient.
This is not for the petition. Petition was written for
whatever, basing on whatever cases your subjective satisfaction has been reached.
My lord.
That you very clear from the counter affidavit that it is committing repeated offences, 8 cases.
Yes, it is for the
that resulted in the subjective satisfaction. So if you are not indicating to the petitioners, and you say that 3 cases we have indicated and 3 cases we have reach the subjective set. That cannot you say at this stage, because you have in your counter affidavit you have stated that it is not those three cases, but it is a
Three cases of
cumulative
NDPS. In
effect of
counter, we
eight
have also
cases.
specifically stated, Your Lordship, what
You have
my lordship,
stated
you have
apart
stated.
from these three cases, other cases. also.
Yes.
So other cases are you have not in the ground. You have not stated those.
No, in the notice.
That is the fact which has influenced the mind of the detaining authority. That's his case.
No, that
and
is
that
not- that is not his
constitutes
case in
that
count-
constitutes
not his case
ground,
in the petition.
and that ground has to have
Madam,
been,
that
should have been
case is
supplied.
not in the writ petition. That is not in the original evidence.
अरे रीट कौन रीट कौन देता सी केम जानिबो आपनको माइंड रे कोन थिला आपण काउंटर फाइल कला परे से जानिले जे आपणकर माइंड को ए तीनटा केस छडा आ पांचटा केस मध्ये इन्फ्लुएंस
But
करी
the test
सी
is
केम जानिबो
whether those three cases are sufficient enough to detain the person or not.
Maybe
whether it's a habitual offender or not. We have stated the three cases of NDPS and other cases are there.
he was not aware what is the what weighed your mind after filing the counter affidavit. Now he asks that, sir, look, not only those three cases but 5 more cases have influenced the mind of the authority in passing the detention order.
That was
but
not told to
I am kept in dark. I have not been communicated that these are the cases, 5 cases which have influenced them, and I should have been given an opportunity also in that.
He could have given a better representation.
Yes.
Madam, as such, no representation is received us. That is other part. This whole question is on 23/7. The order has been passed. That is
Let us say that there is no representation. He may file representation, he may not file. The question is that how can you sustain it if this point is raised on the basis of your counter affidavit that your subjective satisfaction is based on 8 cases and you have only indicated 3 cases to him.
My lord, that may be interpreted as well. That 3 cases were there on the basis of which he has been detained, and after the thorough roving inquiry, we have found that there are other cases.
No, you have not stated. Rather, you have stated, come to page number 20, opposite party number 3. The subjective satisfaction of the detaining authority is based on the cumulative effect of the repeated offense. 8 cases is involved, organized cases, so and so, so and so. So these are the cumulative effect of the repeated offense that influenced your subjective satisfaction.
May I read 2 lines before you? Traffic and supply illicit drug pose a serious and imminent threat. So we have written in the context of this NDPS case.
We do not say that NDPS cases, if a person who is involved in NDPS cases, he should not face the trial. He should not be convicted if you prove the case.
Yes.
Those are not. Question is that here we are on a particular whether the detention order has the legal sanctity or not. That is what
that's
we are
what I am trying to make out.
Because once you detain him in a such type of case, there would be no trial in that case. So once he detained means is detained unless if it is passed, you will come out. Otherwise, even if now suppose in all those 3 cases he has been released on bail, but in spite of that he is in custody because you have passed the order of detention. It's a preventive detention order, and it has been confirmed
by the state result. Yes.
Right? It has been confirmed. So
the test is whether within the 5 years the procedure has been followed or not. That is the sole question.
No, that's not the test. That test is on the 3 on the basis of 3 cases. If you would have done it, justified it, one can understand it.
Yes.
Then we would have tested the other way. But the ground on which you have passed the detention order, all the grounds are not supplied to. That's the case. You have made out for him in the counter.
Yes.
You have made out for him.
We have just stated that he is a habitual offender. That's
there are direct cases, Mr. Bhatia, you are not facing those cases. Direct cases that if apart from these 3 cases which are indicated in the grounds of so and so, the other cases have also influenced, and that is not furnished to the that is a ground.
Yes, that is the first case, and also.
But those cases are not NDPS. That's why we are not
the paragraph. That is CORAM also there. And
which one?
The CORAM is only theft case. It's not NDPS matter.
So NDPS.
The fact.
Logically, see the recent judgment. Judge Joshua Saji was in India. Who judgment are provided. That is available in that sheet.
You find out those decisions.
Yes.
Give me those decisions. Research assistant. Yes, any other decision?
So Justice Saji regarding this communication of grounds plus what have we decided?
This is on the non-supply of statements of the
grounds.
documents. Grounds.
No, I'll give the exact decision. That is not but I have not brought much on it. And our Pappu versus State of Odisha, that is the 2023 SEC online Odisha 113, WP serial number 158 by 2022. All the judgments was have been noted in that particular case.
Since it is not a regular bench, we are making it hard in part. We are keeping it to, let us say, on Friday or Thursday
maybe
at
next
2
week.
o'clock.
Monday.
Any day at 3 o'clock we can keep.
Yes.
3 o'clock.
3 o'clock we will sit.
Tomorrow,
not tomorrow. I have a special.
Yes. Yeah, I know. It is up to us.
Any day next week. Any day.
Friday.
24 ତାରିଖ ଦିନ କଣ ଅସୁବିଧା ହଉଛି ଆପଣଙ୍କର?
ନାଇଁ 24 ସାର୍
24 କହୁଛି ସରି
ହଁ 27
30th ବା 31st କଣ?
ହଁ 31st
single bench.
ନାଇଁ ଆମେ break bench କରିବୁନି। ତିନିଟା ବେଳେ ବସିବ କଣ
10-15 minutes.
ଆପଣ ଏଇ ପଏଣ୍ଟ ରେ ମେନ୍ ଫୋକସ୍ କରନ୍ତୁ ହେଲା।
And Justice Samant's judgment is there.
Yes.
BP Samant.
Yes.
Justice BP Samant judgment direct on this point. Just check it out.
Regarding part put up this matter on 31st of January 2020. Acha, on that day there is a reference of the advocate. We will sit at 2 o'clock.
30th possible. 30th.
ନାଇଁ ନାଇଁ ଦିଟା ବେଳେ ବସିଲେ କାରଣ ସେଟା ଅଛି ରେଫରେନ୍ସ ଅଛି ତିନିଟା ବେଳେ ଏଡିସନ ଗୁଡାକ ଇଏ କରନ୍ତୁ
and come point to point decision
ଆଉ ଏତେ ଦରକାର ନାହିଁ
ଏପଟେ ସେପଟେ ବୁଲା
ଡିଟେନସନ ଅର୍ଡର ଗୋଟେ ଦିଟା ପଏଣ୍ଟ ହେଇଗଲେ ସଫିସିଏଣ୍ଟ
ଆପଣ ଦେଖନ୍ତୁ ଆପଣ ବି ଆପଣ କେସ୍
whether it on counter case.
Yes, sir. ଆଉ କଣ ରହିଲା କଣ ଅଛି
Item number 4.
Yes, item number 4.
Minor. May I please the Workman under section 302 minor. Life conviction is that petitioner is in custody more than 10 years.
You have applied for bail.
Minor.
So have you got the custody certificate that you are in? Whether your bail application was earlier rejected?
Minor.
Which order? अच्छा 26/4/2017 तापरे और रिजेक्ट ही नहीं
No minor. Both the appellant is husband and wife minor.
No, it's all right.
In the meantime, wife already dead minor. Wife already dead minor. Chandri Devi already dead minor.
In this yes, in this criminal appeal there are two appellants.
Minor.
One is Bipin Devuri, the other is Chandri Devuri.
Minor. Bipin Devuri is the husband and Chandri is the wife.
Chandri is dead.
Minor.
And now whether the you have filed the death certificate?
No minor.
Or death
At the
certificate?
time of he was released on bail prior to.
All right, no. This appeal when finally it would be hard
No, today I am pressing for appellant number 1.
ବୁଝିପାରୁଛନ୍ତି ଆମେ ବେଲଟା ଶୁଣିବୁ
My lord.
କିନ୍ତୁ ଗୋଟେ ଆପେଲାଣ୍ଟ ଯେତେବେଳେ ଡେଟ୍ ହେଲାଣି ତେଣୁ ଆପଣଙ୍କର ଏଇଟା କୋର୍ଟର ନୋଟିସକୁ ଆଣିବା ଉଚିତ
My lord.
ତାହେଲେ ସେ ଅପିଲଟା ତା ପାଇଁ ଆବେଟ୍ କରିଯିବ
ଆଜ୍ଞା।
ବୁଝିପାରୁଛନ୍ତି
My lord.
ତେଣୁ ଆପେଲାଣ୍ଟ ନମ୍ବର 2 ଆପଣ ଏଇଟା ବ୍ୟକ୍ତିଗତ ଜ୍ଞାନ ଅଛି ନା
And for the same reason, previously the appellant number 1 already released on interim bail for 45 days on that ground.
On that ground.
My lord.
Okay. 4 19 Where is that?
an order is required to be passed that the appeal so far as this appellant number 2 is concerned abates because she is dead.
I will have a glance on the order of 16/4/2019.
On 16/4/2019.
Bipin Deori will be released on bail for a period of 45 days. As previously, on the first para, it was stated that he will go for make an arrangement for his children, as because her wife and brother already dead. My lord.
What is specific ଲେଖା ହେଇଛି
Paragraph 2, my lord.
କଣଟା ଲେଖା ହେଇଛି
5th line. Wife and brother have already died, and the appellant has furnished the certificate of
ସେଠି
the
ଆପଣଙ୍କର
sarpanch.
submission ଥିଲା
No, my lord. Application of the sarpanch already filed.
So are you aware what is the procedure? Once you bring it to the notice of the court,
My lord.
the court will ask the London State Council
My lord.
to obtain instruction to the concerned IAC and submit the report.
My lord.
And if the report comes, then only the case would abate.
My
It's not that you say that if he is dead, we will abate the case. Right?
Verification is to be
So
done.
verification is to be made. So that has not been done. It's all right, you have been granted bail,
My lord.
interim bail because of your wife's death, but at that time, this exercise has not been made.
My
This
lord.
exercise is to be made before passing an order of abatement, right?
My lord.
So that's one thing. But now you have filed the interim application for bail, and your main ground is that you are detained in for custody for more than 10 years.
My lord.
So what is the allegation against you?
Allegation as per the PW, who is the
Judgment.
eyewitness, my lord.
How many persons died?
1 person.
Eyewitnesses are there, or it's a case based on circumstantial evidence?
As per the PW2, my lord, eyewitnesses.
PW2 is the only eyewitness.
Only eyewitness, but as per the cross-examination of
Just a minute. PW2 hello eyewitness.
my lord.
Who is the doctor conducted PM?
The uncle of the deceased. PW8, my lord.
PW8 is the doctor.
My lord.
Just come to PW2's evidence, let us see.
Bipin Deori is the son of my elder brother. Pitara Deori and accused Chandri Deori is his wife. This is Vikram Deori, is also my nephew, being the son of my elder brother, Sitara Deori. Accused Bipin Deori and this is Vikram Deori are the two sons of Sitara Deori. So different mother. The informant Punni Deori, PW1, is the widow of this is Vikram Deori. The occurrence took place nearly 1 year back at about 7 p.m. on a day in front of our house. At that time, I was sleeping in front of veranda of our house. While this is Vikram Deori was coming near my house, the accused persons came running to him. Accused Chandri Deori dealt a blow by a lathi on the head of the deceased. Vikram Deori. This is Vikram Deori fell on the ground. Accused Bipin Deori, the present petitioner, my lord. Thereafter dealt a blow by an axe on the head of the deceased Vikram Deori, causing profuse bleeding injury. Thereafter, the accused person fled away from the spot.
Okay.
But at the cross-examination, you have stated that I was not examined by the police.
That's all right. Then PW 8.
Lacerated injury, my lord, size 11 into 1 into 5 cm over left partial area of head.
This lacerated wound is can be caused by that lathi, which was used by the wife.
My lord.
But what about this weapon which was used by the present petitioner in giving an axe blow?
My lord.
Which is that injury? Because the other injuries are bruise, abrasion. Apart from that injury, the two other injuries, external injuries you are seeing, those are bruise and abrasion.
My lord.
So
The cause of death due to shock and cause of injury number 1.
Sharp cutting weapon, cause of death point.
There is no corresponding.
Yes, what do you say, madam?
PW2 is the uncle of the deceased as well as the accused. He has stated that he has seen the entire occurrence. He has seen the dealt blow by the accused, the present appellant.
No, you see, two persons,
Yes.
two accused, gave two blows on the head.
Yes.
One of the weapon is
Was lathi.
a lathi, the other weapon is by a the other weapon is by an axe. Now you come to the doctor's evidence, PW9.
Last line.
Page 8, your lordship.
Para 3, cross examination.
So before that,
The
may I read
seized weapon of the offense is not produced in the court today. Injury number 2 and 3
the opinion before that?
are possible on.
Before that, also, may I read the opinion part?
And injury number 1 is not possible in the.
All
What
the
opinion?
injuries are antemortem in nature. Right have been caused by the hard and sharp cutting object. The cause of death was due to shock and hemorrhage caused by the injury number 1, your lordship.
Madam, you are not following there. One weapon is lathi.
Yes.
The other weapon is a
The
sharp
axe.
cutting weapon. Two persons assaulting by these two weapons on the head.
Yes.
So how many injuries are expected on the head?
At least 2 injuries.
Is it there two injuries are there in the head, on the head?
One is the fatal injury and other
No, is there two injury at all?
Head injury.
मुंडरे जणे बाडीरे मारला आउ जणे गोटे शार्प कटिंग वेपन ने मारला आपण निजे कहउछन पूरा दीटा इंजरी कम से कम थिबो कारण से टाइप रो वेपन रे एग्जैक्टली गोटे जगह रे दीटा प्रिसाइजली पड़िबो नै हां एग्जैक्टली सेही जगह रे बाडी पड़िबो सेही जगह रे माने टांगिया रे पड़िबो इज इट पॉसिबल नो दीटा इंजरी थिबा दरकार कम से कम एई टाइप रो जदी घटनाटा एमती असल्टा हेइथादा आपनकर डाक्टर को कहउछन गोटिए मात्र इंजरी देखिली सेडा होची हार्ड एंड ब्लंट वेपन नेइथिबो ए जो बेल पई आछंती ये मारिचंती आक्स इंजरी गला कोडे
Question may kindly see paragraph 2 here.
paragraph
2 of the doctor's.
Yes.
On 10 for 2013, the police officer sent me the axe with a wooden handle and made query as to whether the injuries found in the deceased can be caused by the axe, to which I have answered that the injury is possible by the axe. On his query, I have also answered that the injuries found by me are sufficient in the ordinary course of nature to the cause.
All right, it is possible. Let us say it is possible, but where is that injury?
So he has not specified the injury vis-a-vis the axe, lordship.
दीटा इंजुरी ही नाही आपण केस ही फॉल्सिफाइड हे जाउची बुझ परछन ना
Yes.
आपण निजे वर्तमान कहले दीटा इंजुरी कम से कम एई भली घटनाटा जदी हितांदा दीटा इंजुरी थांदा मुंडे दीटा इंजुरी ही नाही
Lacerated injury, lordship. Other injuries are may
are
not
the
be.
learning counsel for the petitioner and counsel for the state. The learning counsel for the petitioner submits that the petitioner was taken into judicial custody on 22/2/2013 and he was never released on bail during trial. However, during the pendency of the appeal, he was granted interim bail for a period of 45 days in IN number 553 of 2019 as per order dated 16/4/2019, and after availing the same, he surrendered at right time. And therefore, the petitioner has remained in custody for more than 10 years. Further submits that the earlier bail application of the petitioner was rejected on 26/4/2017. Further submits that PW2 Noto Dehuri is the sole eyewitness to the occurrence, who has stated that appellant number 2, Chandini Dehuri, dealt a blow by means of a lathi on the head of the deceased Vikram Dehuri, for which she fell down on the ground, and thereafter the petitioner dealt a blow by means of an axe on the head of the deceased. However, the doctors PW9 has noticed, PW8 has noticed only one injury on the head, which has been opined to be a lacerated wound. The Land Council submits that in view of the medical evidence adduced by PW8, the ocular testimony of PW2 that 2 blows were given to the deceased on his head by 2 accused persons by 2 different weapons is a doubtful feature, and the petitioner has good chances of success in the appeal, and balance of convenience is in his favor. He further submits that the paper book has not been prepared and there is no chance of early hearing. Therefore, the bail application may be favorably considered. Land Council for the state oppose the prayer for bail, place the evidence of PW also PW9. Considering the submission made by the Land Council for the respective parties, the nature of evidence adduced during trial, the discrepancies as pointed out by the Land Council for the petitioner in the evidence of the PW2 vis-a-vis PW9, the doctor, and the period of detention of the petitioner, PW8 the doctor, and period of detention of the petitioner in judicial custody, also absence of any chance of early hearing, we are inclined to release the petitioner on bail. This is the bail application which has been filed by appellant number 1, Karnataka. Yes, allowed. Verification. Huh? All right. The during course of argument, it is submitted by the Land Council for the petition appellants that the appellant number 2, Chandri Dehuri, is dead. Let the Land Council for the state obtain instruction to the inspector in charge of Kemujar Sadar Police Station on this aspect and produce the written instruction obtained from so and so. Yes.
Item 5.
There was a direction to produce the report of Minister November regarding the conduct of the accused with interim day and may allow some time to apply.
Okay. Have you filed any other bail application? No. All right. The Land Council for the state seeks some more time to produce the report from the concerned IIC regarding the conduct of the appellant while on interim bail. It is this matter. After 3 weeks further. Yes. Next.
Item 6.
Report received from trial court at Clark C. Kौन Clark C रे? Has not availed the interim bail. अच्छा. Peruse the report of the learned additional session judge Champua, which indicates that the appellant has not availed the interim bail order on interim bail as per the order dated 27/8/2024, passed in Miss Case number 80 of 2016. Matter will be listed in due course. Yes.
Item 7.
7 you are for the petitioner. What is your good name? Ashish. You have got power in this case. You are mentioning on whose behalf? On behalf of my senior Mr. Kanun. Acha. Mr. Swanso makes submission on behalf of Mr. Milan Kanungo and senior advocate for adjournment. Place this matter. Date the exam to Bishop for yes. Thank you.
Item 8.
Surrender report of the appellant to fact state.
And you are to produce the report from the IAC regarding the conduct. Have you got it?
No.
All right. Period the surrender certificate of the appellant at Class C. The land council for the state seeks some further time to produce the report from the IAC Ujala police station regarding the conduct of the appellant while on interim bail. Yes, next.
Item number 9.
Time. How much time you want?
1 week.
6 for an adjournment. Yes, next.
Item number 10.
Item
11.
All right, adjourn. Next.
Item 12.
Appearing on behalf of Mr. Panda. I pray that it may be listed next week.
All right.
We will serve the report.
Land counsel for the appellant fixed for an adjournment and submit that you will supply the deposition copies of all the witnesses examined in the trial court, the land counsel for the state of this matter in the week commencing from 10th of February 2025. Yes, next.
Item 13.
Your name is Orolina Pal, right? So how many years of practice you have?
6 years.
6 years. So it's a case under section 302. The problem is that in the Anokilal case, it is stated that if you are not having the practice of 10 years in 302 cases, death reference cases also, you cannot be engaged as the advocate. Yes. We are, because of that decision, we have to engage someone till one counsel of your choice who is having.
He can also render assistance.
You will remain with him, but till one name.
10 years.
Just give the name. Just give the name.
So that you can assist.
You can assist. You must have gone through the brief. Just for that reason, just give you the name. But you should have practiced 10 years of that. That's all.